All right. Good morning, everybody. My name is Dana Sparks, and I am the director of the Georgia Real Estate Academy, which is the school that is offering this course for CE credit. And this course is weird contract forms, all you need to know about brokerage agreements, exhibits, amendments, and special stipulations. Now, it's not all you need to know, or we would be here for the remainder of the year at least, right? But I am going to cover basically the intent of this class is to cover the forms that don't typically get covered in a contracts class. Generally speaking, at least in the contracts classes that we teach through this school, Georgia Real Estate Academy, we typically just cover the purchase and sale agreements, the loan exhibits, the seller's disclosure forms, and the community association disclosure exhibit, as well as just some of the other ones that are used over and over. There's not enough time to cover the brokerage agreements and all the other amendments and exhibits that are available to you guys and you use on a fairly regular basis. So that's what this class is. Again, my name is Dana Sparks. I am the director of the Georgia Real Estate Academy. I am also the qualifying broker of Maximum One Greater Atlanta Realtors. Now, the only reason I tell you that is because I still have daily interaction with the contracts, the GAR, Georgia Association of Realtors forms, as well as the RE forms. Now, I don't see every contract. We have two compliance brokers that see every single contract. I just see the contracts that have issues. So, maybe a couple a year. So I just wanted to give you a little bit of context that I don't sell anymore. I'm not a competing broker, so I don't actively sell anymore. I just teach classes and manage and broker. So the way we are doing this class is, obviously it's virtual, so welcome everybody. If I see a lot of familiar names as well as a lot of new names, so if you are a repeat offender, so to speak, if you are a repeat student of our classes, welcome back. We're so glad you're back, and you know what to do. If you are new to our school or new to Zoom, welcome. Get used to it. I think this is going to be the wave of at least the very near future. The Georgia Real Estate Academy is going to offer our CE classes virtually at least through the end of the year. So what we do, it takes us 3 to 5 business days to get the CE credits recorded with GREC, because there are a set of 3 reports that we have to amalgamate. The registration report, the attendance report. Zoom keeps track of you guys when you're on, so that we're sure you are actually attending for the full session. You didn't just turn on your computer and walk away. But how could you with this topic, right? As well as the chat. So we are going to interact through the chat format. So right now in the chat, if you have not already done so, please type in your name, your email address, your real estate license number. Also in the chat, I am going to share with you guys, there are copies of the handouts of the PowerPoint I'm going to go through. You do not need them for this class. There are 24 handouts. So you don't need them for this class, but I wanted to let you know they are there for your reference after class. It's all the forms that we're going to talk about with underlines of things you need to pay attention to. Additionally, we are recording the CE class for your reference after class or later. So I'll talk a little bit more about that as we get further on. During the break, I will open it up and take questions from you guys through your microphone, and I'll stay afterwards. But again, throughout the course, please type in your questions in the chat. So we've got a lot to cover. I hope everyone is in the right place, and I hope you guys enjoy the class and get some information from it that you came to get. So the first thing I am going to do, and again, my name is Dana Sparks. The first thing I'm going to do is share the notice to students. So let me share my screen. And Let me go to the notice to students. I'm gonna make that a little bit bigger so everybody can read it. All right. Notice to students for the virtual broadcast of CE classes, GREC approved classroom classes. The Georgia Real Estate Academy, GREC school number 6915, with the end date of renewal being December 31st, 2022, presents to you the following course of study. Weird contract forms. All you need to know about brokerage agreements, exhibits, and amendments and special stipulations. GREC course number 65149. This is a virtual remote broadcast of an approved in-class course. It's 3 hours in duration and approved by GREC for CE credit for 3 hours. Now, for whatever reason, we tend to have a lot of students on here from all throughout the country. This is just for credit for your Georgia real estate license. The school is an approved school through the Georgia Real Estate Commission, and we can only give credit for your Georgia real estate license. So if you are a real estate agent from another state, you are more than welcome to stay on and get the information, but you will not get CE credit, and this is specific to the Georgia contracts, specifically the GAR, Georgia Association of Realtors contract. There's no homework or required written exam. You must be on time and present for the entire remote broadcast of the instruction. And as I mentioned, we will maintain attention through the chat function. Continuing education notice. Students may only receive credit for a specific course number once every 12 months. If you have already received credit for this course within the last 12 months, and not the topic, but the course, which is the course number 65149 through school 6915, then you won't get additional credits. Prohibition of recruiting. There's no recruitment for employment opportunities for any real estate brokerage firm in the class or on school premises, which is loosely interpreted in these Zoom meetings. If so, please report any effort to recruit to myself as the director of the Georgia Real Estate Academy. Heidi Kelly is the coordinator of the Real Estate Academy, and she is the one that records the CE credits, or contact GREC themselves. Again, as I mentioned, I do have handouts for your reference for after class, but what I have found a lot of students do is they'll take out their cell phone and they'll take a picture and snap a screenshot. So if you need to get in touch with us, there's our information. And we are going to get started. So let me move this out of the way. All right. Yes, it doesn't matter if you belong to a board or not. Everybody is licensed through the Georgia Real Estate Commission, regardless if you belong to a board of realtors or not. All right. Weird contract forms, and some of them are weird, but they're not all weird. All you need to know about brokerage agreements, exhibits, amendments, and special stipulations. GREC course number 65149. The focus is on the Georgia Association of Realtors contracts. I am the instructor, and again, this course is offered through the Georgia Real Estate Academy, GREC school number 6915. There is my email address. And the first thing we're going to start with is where everything starts, the brokerage agreements. And we're going to get specific about the listing agreement in just a minute. But generally speaking, brokerage relationships, a broker may work with the public as a client or a customer. So the public has a choice when they come to you as the agent, if they want to be your client or your customer. And also, please note, generally speaking, in this class and on the forms, when it says broker, the word broker also means brokerage as a firm and affiliated licensee, which is you. All right, hang on one second. There we go. So a client, if a public person is working with you and your broker as a client, that means there is an agency relationship. In Georgia, the agency or client relationship is contractually created. sellers can be a client or a customer. Buyers can be a client or a customer. So per our Beretta law, which is OCGA 10-6A-4, the broker's legal relationship to customers or clients is all spelled out. This isn't just what your broker tells you or what you learn in this class, but it is actual law. And Beretta stands for the brokerage relationship for real estate transactions. And it basically says that a broker shall not be deemed to have a fiduciary relationship with any party or fiduciary obligation to any party, but shall only be responsible for exercising reasonable care. And I know that's strange. You think, gosh, in pre-license school, I heard that if you have a client relationship, you do have a fiduciary responsibility to that person if they choose to be your client. Well, when they choose to be a client, the brokerage and you as the agent, you owe them only the duties and obligations as set forth by Beretta law and in the listing and buyer brokerage agreements. And in essence, what that means is you still have, let me go back just for a second. You still have a real estate license that was issued to you by the state of Georgia. By virtue of that, you are held to certain license laws in order to keep your real estate license in good standing. So that is a little bit difference between why it says not a fiduciary relationship. So the obligations that you do have, of course, even to a customer, is to be open, honest, truthful, not misleading, not discriminatory, and to look out for your client's best interests. But it doesn't mean that you have to keep all your clients' secrets. For example, if you are an actual attorney and you do have a true, in the full sense of the word, fiduciary relationship with your client, if you're representing a murder suspect and that person tells you, if you're an attorney, that they did it, you can't tell that. You're not allowed to tell that. That's the client-attorney privilege. In real estate, however, let's say you go on a listing and you're representing a seller, and the seller tells you that there is a leak in the property behind the walls that nobody can see, and they put this big old huge heavy gun safe in front of it, and they tell you, the agent, shh, don't tell. They'll never know it until they close and move in. Well, that is not a quote unquote secret that you can keep. By virtue of you having a real estate license from the state of Georgia, you have to disclose a material latent defect of which you have knowledge. Now, by law, the seller does too, but you do too. So you can't keep, you have to look out for your client's best interest, but you can't keep a secret when it's not in the best interest of the contract or of the parties. So for the agency relationships, there is seller agency, which is a client relationship with the seller. Buyer agency, client relationship with the buyer. Designated agency means there's one broker and two agents, and each agent has a client relationship with both the buyer and the seller. The way to remember that, where that term comes from, is the broker has designated agent A to work with the buyer and agent B to work with the seller. Dual agency is one broker and one agent, and that agent has a client relationship with both the buyer and the seller. Now, I will tell you, if you are a broker who also sells, you may not participate in a designated agency contract, and that is also stated in Beretta law. So if you are a broker of a firm, not just having a broker's license, not an associate broker with a firm, but if you are the qualifying broker of a firm, you cannot engage in a designated agency relationship if another one of your agents is working with one of the clients. All right, license law requires the signature on a brokerage agreement if the broker is working with the public as a client. There's no law, however, that requires the public to sign anything to work with you as a customer. But it's always a good idea to have the public sign something that describes their relationship with you and the broker relative to their transaction. Additionally, your broker may have a policy on having customers sign the documents, and there are GAR and RE forms documents that describe the customer relationship, and we'll cover those in this class. So the seller agreements, again, the agreement creates the client relationship here in Georgia for the transaction of real property. For GAR, it's F101, the exclusive seller listing agreement, and in the RE forms, it's RE151, exclusive right to sell. There are forms, again, that describe the customer relationship. In GAR, it's the authorization to show unlisted property for the seller, and in the RE forms, it's the seller authorization to show property not listed. Okay, okay. Pop quiz. You already saw the answer if you were paying attention. Pop quiz. Does the non-exclusive seller listing agreement create a client relationship as well, or would that be for a customer to sign? Type it in the chat. What do you think? So the exclusive listing agreement creates the client relationship. What about a non-exclusive listing agreement? Does that create a client relationship? Yes, yes. Customer, no. Yes, yes. All right. The answer is yes. Even the non-exclusive seller listing agreement, that also creates a client relationship between your broker and that public seller. Now, the difference is it's non-exclusive. So that public seller may sign a non-exclusive seller listing agreement with your broker, with broker B, broker C, broker D, and broker E. It creates a client relationship with a multiple number of brokers. And the broker that gets paid is the first one that can demonstrate procuring cause of sale to bring about a sale of that listing. So it does, however, still create the client relationship. It's just that it creates it with more than one broker. Also, if a seller has signed a non-exclusive seller listing agreement, it is not allowed to be in FMLS or Georgia MLS. FMLS and Georgia MLS will only accept listings where the seller has signed an exclusive seller listing agreement. In the RE form, it's called the non-exclusive right to sell. All right, buyer agreements. Again, the buyer brokerage agreement creates the client relationship. GAR, it's F110, RE form, exclusive buyer brokerage. And then there are additional forms that describe the customer relationship. In GAR, it's the F116, the agreement to work with buyer's customer, RE form 159, acknowledgement of customer. Same question, what about the non-exclusive buyer brokerage agreement? Well, yes, the non-exclusive buyer brokerage agreement also creates a client relationship between that buyer and the broker. It's just that it creates a client relationship with broker A, broker B, broker C, broker D, and the broker who gets paid is the one who basically gets that buyer under contract. And in the RE form, the non-exclusive buyer brokerage agreement is RE161. All right, so we are going to continue on and go through the listing agreement. Again, this course is going to focus on the GAR forms because there's a lot to cover there. Generally speaking, the concepts that we're going to talk about are the same in the RE forms, but I just have time for the purposes of this class to go over the exclusive. So here we go. Let me see if I can make this bigger. Nope, that doesn't help. There we go. All right. So this class is not going to be A to B fill in the blank for everything. I'm just going to cover some general issues and then cover some of the important concepts in more depth. So in the exclusive listing agreement, of course, you're going to fill in the property address. But here in Georgia, especially in Metro Atlanta, you absolutely need a legal description. There are more than one Peachtree roads in Atlanta, in Georgia. Therefore, there could be more than 1, 2, 3 Peachtree Road. So you absolutely need a legal description to identify the actual parcel of property that the seller is agreeing to sell. Then the listing period. You must fill in the date of when it begins and when it ends. And that is actually license law, that on a brokerage agreement, you must fill in an end date of the listing period. Then you fill in the price that the property is being listed for. If the seller does or does not authorize you to assist in the negotiations, and that seems weird. Well, gosh, why are they hiring me to sell their property? But there are some real estate brokerages in our area where they sign a client relationship with that broker, but that broker does not negotiate on their behalf, and a co-op agent negotiates directly with the public. That is only allowed per license law if the broker gives that permission, and that's where it is spelled out here. Marketing. If you put in here that you agree to put a property listed in whatever listing service, FMLS, Georgia MLS, Navica, what other listing service, that means you have to list it in that listing service. Now, commission. This is why we start with the listing agreement. Every part of the money gets started on this agreement. So basically what this says, well, let me ask you guys a question before I explain this. You as an agent, when you are working with the public, regardless of if it's a, okay, let me ask you if you are a buyer. If you're a buyer's agent and you go under contract, you get binding and you go to closing, what is the document that describes how you as the agent get paid when you are working with a buyer in a real estate transaction? Type it in the chat. What is the document that describes and explains and all the amounts of how much your commission check, how much you are going to take home, how much you get paid from a transaction after closing when you're representing a buyer? Instructions to closing attorney. What else? Independent contractor agreement. Instructions to closing attorney. Instructions to closing attorney. Some call it commission agreement, closing attorney, listing agreement, instructions. All right, buyer brokerage agreement. All right, you guys. So, of all those, there were only 2 correct answers. The answer is your independent contractor agreement. That is the only document that describes how you as the agent get paid. As a matter of fact, that's one of the factors that you look at when choosing a broker with whom to work. So let's talk about this. How does the money all trickle down? In this listing agreement, it says the seller agrees to pay the broker at closing. Which broker? The listing broker. So all of the money, the entire commission, is contracted for in this listing agreement. The seller is paying the money, and the seller agrees to pay the listing broker. Then Part B says the listing broker agrees to pay the cooperating broker, which would be the selling broker working with the buyer, a certain percentage or dollar amount. So in other words, under 6A, the seller agrees to pay that A, that is all the money. So that is whatever total commission, 6, 7, 8, 10% commission, or a total flat fee. Then in B, the listing broker agrees to share that commission with the selling broker if there's a selling broker that brings a buyer. And they agree to share what percentage of the sale price. So the percentage in B needs to be smaller than the percentage in A, or else the listing broker is working for free. Now this is the seller, public seller paying the listing broker. Then the listing broker is paying the buyer's broker. You as the agent get paid from your own broker, whether you're representing the seller or the buyer, by virtue of what you agreed upon in your independent contractor agreement. So the instructions to closing attorney, that describes how much the seller is paying the listing broker and how much the listing broker is paying the selling broker. That's all brokerage money. You don't see your name on that final HUD statement, do you? No, you see your company's name. The buyer brokerage agreement, that describes how much, if any, the public buyer is paying your broker. So just a little bit of a distinction there. But with respect to this form, again, the commission number in A should be bigger than that in B. All right, protected period. This is the length of the term that the commission is protected after the expiration or termination of the listing agreement. All right, so you have to fill in all that information that we just talked about. Oh, also it talks about agency that is not permitted. And again, that is going to be, I'm sorry, it's down here. Oops. It is down here where it says agency and brokerage. The following types of agency are not offered by the broker. Again, as an agent, you guys need to check with your broker if there are any agency relationships that your brokerage has a policy against. Dual agency, for example, is not illegal as long as there is disclosure and written consent by the parties, but there are some brokers that have a policy against it. All right. Now, the next section talks about special circumstances, and where it talks about special circumstances, it talks about bankruptcy, divorce, so forth and so on, short sale, seller not on title. Again, you only list these not if your public seller is going through a bankruptcy or has gone through a bankruptcy or divorce, but you only check these items only if there is required third-party approval. In other words, if the bankruptcy court has to sign off on a contract, if the divorce court has to sign off on the contract, that's when you list these special circumstances. And it says approval must be obtained. That was all the fill in the blanks in paragraph A. Then we go to paragraph B that explains all the requirements, promises, and obligations of the parties. And the first thing, it talks about the exclusive listing agreement. It must be in writing and signed by the parties. It says, and then it talks about for termination. Any agreement to terminate this agreement, that sounds weird, any agreement to terminate this agreement or any subsequent agreements must be in writing and signed by the parties. If you are under contract and you get fired, if you're a listing agent, you get fired, actually a buyer's broker too. If you're already under contract, you may get fired from representation, but not necessarily from compensation. It depends on what agreements are signed that actually terminate the brokerage agreements, a unilateral agreement or a mutual agreement, and I'll cover those a little bit later. I'll cover those right now. So if a seller, or if you can fire your clients as well, but if a seller wants to fire you or terminate the brokerage agreement, there is a unilateral termination of the agreement or a mutual one. So let's talk, let me see if I have it in the next slide. So in the unilateral termination of the brokerage agreement, it can be terminated by the broker or the client, and it does not eliminate the seller's obligation for commission. So let me zoom in on this just a little bit and let me show you. Here's the part where you terminate by the client, and down here it states, so of course you're still going to have to give this form to the client. Unilateral termination of this agreement does not eliminate the client's legal obligation to the broker for commission and or fees owed as specified in the brokerage agreement, or termination by brokerage. And same thing, it does not alleviate the client's obligation for commission. Now, the mutual termination of the brokerage agreement, that doesn't get terminated unless you get signatures from both the broker and the client. And in that, you negotiate whatever fees you wish to negotiate. In other words, let me show you this. So this is the mutual, and it states, if the brokerage agreement is a listing agreement, costs to remove early listing from any MLS service shall be paid by the client. But here's where you negotiate the fees upon mutual termination, mutual meaning agreement between you, the agent, and your broker, as well as the seller. Then there are no further responsibilities, and you mark in what survives the agreement. Does the protection period survive? You would negotiate in here an amount to reimburse the broker for any fees or cost expenses, and you would negotiate any final settlement, any and all claims. And again, it has on here a release and hold harmless from any lawsuit. So in other words, sometimes if this is where you would negotiate for any fees. All right. Now, there is another form, which is the amendment to the contract, to the listing contract, or any brokerage agreement, whether it be the listing agreement or the buyer brokerage agreement. So in the GAR form, I'm sorry, let me back up. That is, you would put any terminations in the RE forms under the amendment to the contract. But while we're here, there is an amendment to the brokerage agreement. I should have included that, but I didn't. And that is where you amend the brokerage agreement or write any changes. For example, let's say you get you and the seller agree on a new listing price. Well, if you're going to do that, then you're going to use the amendment to the brokerage engagement and have that seller sign agreeing to the new listing price. All right, moving on, it talks about the listing period. Now, what happens, so we already talked about the dates. So what happens if your listing agreement expires, let's say it expires August 31st, but you're already under contract and you're closing on September 5th. Well, if you are already under contract, the listing agreement automatically extends through the closing of a contract if that contract is scheduled to close after the expiration of the listing agreement. Now, what happens if you have a listing, you go under contract, that contract terminates? So in other words, there was a certain number of days that this listing was off the market because you were under contract with another buyer and ended up terminating. You are allowed to add those number of days that you were under contract to, you can extend the listing agreement by those number of days. But in order to do that, you must send a notice of that extension to the seller before the actual expiration date of the listing. It's not automatic. It's automatic in that the seller doesn't have to agree because they agree when they sign the listing agreement, but it doesn't get invoked unless you send them notice prior to the actual expiration of the listing agreement. Now, when it talks about the seller's duties, one of the things that's really important, it says the seller is responsible to refer all inquiries regarding the sale of the property to you, the agent. So in other words, sometimes your sellers will talk about their house for sale at work or at some sort of activity, or will post it on social media or something along those lines, or they'll have somebody just come knock on their door. Any inquiries that the seller gets regarding the purchase of their home, they are obligated by signing this to refer those to you. Also, they're supposed to make the property available for reasonable showing at reasonable times, and make sure that they disclose with accuracy any information regarding adverse material facts regarding the property. That's even if they are selling it as is. If you're selling it as is, generally speaking, that means the seller is broadcasting that the seller is not going to do any repairs to the property. That does not alleviate a seller's contractual obligation and legal obligation in Georgia to disclose any, legally, they need to disclose any latent material defects with the property. contractually, they must disclose all adverse material facts with the property, whether they're hidden or not. Then we talk about marketing. And basically what this slide says is, let me zoom in again. It says, look, Mr. and Mrs. Seller, we do not always have control over the marketing. For example, we know that the MLS services will, you know, Zillow, Trulia, a lot of the online listing sites sweep the information from the MLS services, and we as the broker slash agent don't necessarily have control over that type of marketing. And then it talks about media, and that the seller agrees not to place any advertisements of the property themselves without prior written consent of the broker. Now, it also talks about the MLS services. Let me go on to the next slide. So again, broker doesn't, that's where it is in the contract, and this is what it's talking about. As I mentioned, broker doesn't have control over some of the online marketing. Any photos or videos that are purchased or taken by the broker belong to the broker. If they are purchased or taken by the seller, they belong to the seller. Now, if you are a listing agent and you are listing a property that has been listed with another broker and has expired, you absolutely may not, even if they belong to the seller, even if the seller gave them to former broker, you may not copy them from FMLS. They are copyrighted once they are in FMLS. So you can get them from the seller and make sure you get something in writing that the seller actually gave them to you. But you absolutely cannot just copy and paste pictures from FMLS from a previous listing. And again, it says about not marketing on their own without your written permission. Now, it talks about if you're going to put them in the MLS services. It states that you must list them, put them in the MLS services within 1 business day of when the marketing begins. The marketing refers to flyers, a sign in the yard, putting it on your website, so forth and so on. So FMLS and Georgia MLS have a coming soon category or label that can broadcast that and keep you in compliance with the listing agreement. If you sign a listing agreement and the seller doesn't want it anywhere for a certain period of time, you would have to write that as a special stipulation. But that also means, so in other words, if you sign a listing agreement now, because you don't want to post date the listing agreement, because you don't want, let's say the seller has some fixing up to do, or let's say it's the holidays and the seller's having family in town and they want to list with you, but they don't want to list it, they don't want it on the market quite yet. Well, you don't want to post date the listing agreement because it doesn't start until you have it started, and you don't want another broker to come in and have that seller sign with another broker when they're ready. But you don't necessarily want to put it in the listing service. So as long as you have that in writing signed by the seller, you would add that as a special stip. But that also means you may not show it to anyone. You can't show it to your own clients. You can't show it to buyers of anyone else in your firm. You can't pre-advertise it. If you're going to pre-advertise it, you have to do write it as coming soon. What if the sales contract was terminated after the listing period notifies? So if you're under contract, I'm reading the question. So thank you, Amy. If you're under contract and let's say the listing agreement expires August 31st, we're under contract with a buyer, and that buyer contract is scheduled to close September 5th, it terminates. It depends when in the course that it terminates. If it terminates prior to August 31st, you need to send a notice to the seller that your agreement is being extended for 5 more days. If you don't send that notice to the seller of the extension, once that purchase and sale agreement terminates, you no longer have a listing agreement with that seller. All right. Commission. Let's talk about commission. So here is where it's paragraph B6 where it talks about commission, and it states that if the seller enters into a contract, the seller agrees to pay the broker commission at closing. In addition, the seller agrees to pay the broker commission if any of these issues happen. And the broker shall share the commission with the co-op broker, if any, who procures a buyer for the property by paying the cooperating broker the percent, and we discussed that at the front page. If the seller has unilaterally terminated a listing agreement on the property with a different broker, unilaterally, that's the key right there, unilaterally, the seller may also owe a real estate commission to the previous broker in certain circumstances. So, what is all that saying? Basically, the seller agrees to pay commission. The commission obligation does survive the closing. Seller agrees to pay the commission if they default on the listing agreement. In other words, if they work with a buyer and the buyer and the seller get together to cut out the brokers, seller still owes commission. Now, I often get asked as a broker, what happens if a seller receives a full price offer? Are they obligated to go through with the sale? And marketing, yes, correct. FMLS has now also expanded recently to the MGMLS. So if you work in that area, make sure that you include that on your listing agreement. So again, there is a lot of agents believe, for whatever reason, that if a seller receives full price offer, they must take it and must sell the property. That is not true. It is described in the brokerage engagement when I went through that whole list, the circumstances under which a seller is obligated, and it says not obligated to sell, but obligated to pay a commission. And here's what those are. If the seller gets a full price offer, excluding fees, commissions, and closing cost contribution. So in other words, whatever the house is listed for, if you add the fees, doesn't count for commissions, but closing costs on top of that, if the full price that they net after fees and closing costs equals or is greater than the listing price, that's what that means. Additionally, in that purchase and sale agreement from the buyer, there must be no contingencies and there cannot be any due diligence period. Additionally, there are no warranties outside of what is in the seller's property disclosure statement given to the buyer, and that contract must close between 30 and 45 days from the offer date. So if all of those circumstances happen in one offer from a buyer, then the seller is obligated to pay a commission. And then that last part I read is that a seller may owe a commission to a previous broker if they had unilaterally terminated the previous listing agreement. Now, protection period. So this is going to be an eye-opener for some of you. For some of you, it may not be. I have a YouTube channel called Real Estate Made Crystal Clear. The intent of my channel is to discuss in depth the real estate contracts in Georgia, specifically GAR and the RE forms and license laws. My intent is to talk about these for any and all agents within the state of Georgia. So the reason I bring that up is I just released, I believe last week or 2 weeks ago, a video discussing this in depth, but I'm going to discuss it here for the class. So the protected period is for that certain, the commission, the listing commission is protected for a certain time frame, whatever time frame you negotiated in paragraph 7A. And basically what it is if the seller goes under contract or sells to a buyer who was introduced to the property during the term of the agreement. And what it specifically states is to any buyer who made an offer or was introduced to, visited, received information on, inquired about, or otherwise learned of the property during the term of this agreement. The intent is the fuzziness is a lot of you listing agents will, or a lot of buyers will learn about a property that you have listed through a variety of sources. There's online, they could find it through your website, your company's website, any brokerage website, Trulia, Zillow, Redfin, Realtor.com. There are a number of websites that a buyer can learn about the property. Additionally, a lot of agents will have a buyer on some sort of automated drip from the MLS services, where when a new listing pops up, that information goes directly to the buyer. So it's very vague, and the intent of this is that if you actually discuss that property or knew that another agent had a specific buyer that was talking about this property, or talked about financing or the terms of a contract, so forth and so on. So again, the further definition of that would be defined by a judge or arbitrator. But here's the thing, this last part, this is the thing that surprises a lot of people. No listing commission shall be paid to the broker of this if this agreement has either expired or been terminated upon mutual written consent of the broker and seller, and the property is sold or contracted to be sold to a prospective buyer by or through another licensed broker with whom the seller has signed an exclusive right to sell listing agreement. So what does that mean? So let me give you an example. Let's say you're the listing agent. You have this listing, we'll just keep the same dates, through August 31st of this year. Not under contract, you haven't been under contract. You get a buyer's agent that shows a buyer the property on August 30th. Your listing agreement expires on the 31st. You get a showing on August 30th. You contact that showing agent that afternoon and you're like, what do you think? Are your buyers interested? The buyer's agent says, yes, they're really, really interested. And you're like, great, send me a contract, send me a contract. Well, you wait and you wait and you wait. The evening you contact that selling agent again. Are your buyers writing a contract? Well, I'm still talking to them about it, but I don't have anything. You don't get anything that day. August 31st comes, nothing, no contract. Your listing agreement expires at 11:59 p.m. on August 31st. On September 1st, your seller listed with another broker to sell the house. They signed a new listing agreement with another broker to sell the house. Your listing expired. On September 1st or 2nd, guess what you get? You get an offer from the selling agent that showed it on August 30th. Is your commission protected? You showed it. You can prove through the super lockbox that it was your listing, your lockbox, when that showing agent showed it on August 30th. Listing expired, seller listed with a new broker. You get an offer from that buyer on September, let's just say September 2nd. Are you entitled to commission on that transaction? Yes, yes, yes. No, not from what I'm reading now. The answer is no. Your protection period ends the moment that public seller signs a new listing agreement with a new broker. Even if that buyer saw it during your listing period on that commission, nope, it goes to the new listing agent. So you have a duty to present that offer to the new listing broker. So make sure you listing agents understand that you are not protected. The protection period ends when the seller lists with another broker. Now, if the seller had not signed a new listing agreement, then absolutely you're entitled to that commission. But yep, that's awful. Nope. Sell it, get it sold during the time of your listing agreement. Get it sold during the time of your listing agreement. Wow. Yep. When was that changed? That has been in there for a long time. Been in there for a long time. Now, when we get to the buyer brokerage agreement protection period, we'll discuss that in depth. But for the listing, no, and here's what it says: no listing commission shall be paid if there's a contract through another licensed broker with whom the seller has signed an exclusive right to sell listing agreement. All right. Couldn't you at least get a referral commission? Yeah, that would be a great idea. Contact the new listing agent and try to negotiate for a referral fee from listing agent number 2. Is listing agent number 2 obligated? Absolutely not. You didn't get it sold during the time of your listing. All right. Just wrong. Nope. Price it right. Price it right. Get it sold sooner. Sometimes, you know, unfortunately for initial listing agents, the seller isn't quite ready to price it where the market is stating that it needs to be priced until some time goes along and they don't get any offers. But there's a joke, but I'm not gonna tell it. So, all right, moving along. Seller default. All right. Oops. If the seller defaults, in other words, if they quote unquote fire you, or if they unilaterally terminate the listing agreement, then the seller shall reimburse the broker and affiliate licensee for costs and withdrawal fees from the MLS services. And that's where it's spelled out here in paragraph C1. Point of practice, you guys, you listing agents, you need to keep records, buyer's agents too, and receipts of all of your hard costs associated with each and every listing, including mileage per your listing, because it states that the seller, if they default, has an obligation to reimburse the broker, including for mileage at whatever rate the IRS is allowing as a business deduction. All right, moving along to the seller's property disclosure statement. You guys, your listing agreement specifically states that the seller has 3 days to complete the seller's property disclosure statement and return it to you. So a couple things. You need to make sure to give the seller, as well as the lead-based paint exhibit, if the property was built prior to 78. So you must give the seller those forms to complete when you are actually signing the listing agreement. F301 is the seller's property disclosure statement. 316 is the lead-based paint exhibit, and CB04 is the lead-based paint pamphlet, or you can get that from the EPA website, government website. Now, so what happens? You guys, a lot of y'all have sellers that don't want to complete a property disclosure statement. If the seller is not going to complete that, you must make it a special stipulation in the listing agreement. If you don't, they're obligated to complete it and return it to you. So you would just add a special stipulation that states, per paragraph C2, seller will not complete a seller disclosure statement. But without that, they're obligated to do so. You cannot stip out a lead-based paint exhibit, just so y'all know. Now, additionally, it talks about hazardous conditions on the property. The seller has the duty to correct those or make those aware and eliminate any dangerous or hazardous conditions to anybody that enters the property. Then there's fair housing laws. Your seller must also comply with state and federal fair housing laws. You as an agent must, and there are also license laws regarding fair housing, but your seller as a public person selling a house also must comply. This is also in the buyer brokerage agreement as well, and it's in the purchase and sale agreements. Now, the GAR contract adds 2 additional groups. So the 7 federally protected groups, as well as protected groups in the state of Georgia, are race, color, religion, national origin, sex, familial status, and disability. The GAR contract and the RE Forms contract add the additional groups of sexual orientation and gender identity. In other words, a seller may not discriminate against a person based on those two, on any of those issues. Point of practice, you listing agents, give your seller, I would do it for buyers too, there is a seller fair housing brochure. If you just go to Google and Google fair housing for selling my house, or fair housing brochure, or fair housing pamphlet, you'll find a number of pamphlets. This was a good one under the nationalfairhousing.org. This is a pamphlet that I suggest you get into the hands of your seller. Oh shoot, I didn't mean to click on that. Well, it's going to take us there so we can all see what it looks like. This is the National Fair Housing Organization. There are fair housing brochures in English and Spanish, and there are ones for sellers and buyers, and a number of those. Okay, now let me go back. There we go. All right. And then, of course, it goes on. I don't have it here, but it goes on for, then you would list any consumer brochures, and you sign, and the seller signs. I'm going to cover the consumer brochures a little bit later. Now, what if the seller wants to work with you as a customer? What you are going to use is the authorization to show authorization to show unlisted property. And did I skip something? No. In that form, it has similar information as the listing agreement. It talks about listing price. It talks about broker protection disclosures. It talks about time frames. It also has a protection period. It also has commission. So if you're working with a seller as a customer, generally speaking, we think of somebody that is a for sale by owner. But there are other circumstances when you're working with a seller as a customer. For example, let's say you have a buyer with whom you are working. You've signed a buyer brokerage agreement, so your buyer is your client, and the buyer or you learn of somebody that wants to sell their house, but they haven't yet listed it, but it's going to be perfect. Or you have a past client, just someone that you know that's thinking of selling their house, but it's not listed yet. Well, that might be the situation where you're going to get the deal done. You're already working with the buyer as a client by virtue of having signed the buyer brokerage agreement. In that situation, you would have the seller sign the authorization to show unlisted property, and that seller would be your client. In that agreement, it has a place to negotiate commission. In the event during the term of this agreement, the property gets sold, the owner agrees to pay the broker the commission as follows: 1% of the sale price or a flat fee. And under brokerage, under brokerage relationships, this is the important part. This is where it describes that the seller, the public seller, is a customer. Paragraph 13, this agreement shall not be construed to create a brokerage engagement between the owner and the broker, but is limited to the owner's permission to give the broker to show the property to prospective buyers pursuant to the authorization that's listed in this agreement in exchange for compensation. The parties understand and agree that the owner is the broker's customer, and the broker may perform ministerial acts for the owner. Now, if sometimes there are two agents involved, one representing the seller as a customer and the other representing the buyer as a client, or vice versa. It doesn't matter. If the public has chosen to work with your brokerage as a customer, that does not, absolutely does not, give the co-op agent the authorization to quote unquote cross a sign and contact that public person directly. The public person has still chosen you and your brokerage to work with. It's just that the legal relationship is that of customer and not client. And then it goes on to say that state law prohibits, and again, this is the Beretta Act that we covered earlier. State law prohibits the broker from representing the buyer as a client without first entering into the written agreement, and that is the Beretta Act. Then again, it talks about Okay. I'm sorry, you guys, I'm confused. We're back on the exclusive listing agreement again. So I'm not sure why that slide was out of order. So I apologize for that. But anyway, we're back on the exclusive listing agreement again. At the bottom where it talks about commission, I think I talked about this already. Fill in the commission the broker's entitled to. So this says under paragraph 5A, okay, I know what I'm talking about. The broker shall be entitled to the following commission at closing. B says, in the event the seller does not pay the broker in, this is the buyer. My slides are all confused. Okay, hang on. Nope, okay. Rewind that last couple minutes. Okay, we finished with the seller exclusive listing agreement. We talked about working with the seller as a customer, period. Now we're moving on to the exclusive buyer brokerage agreement. Okay, now we're back on track. So now we're talking about the buyer brokerage agreement. And again, it references Beretta that in order for a buyer to work with you as a client, they must sign the buyer brokerage agreement per OCGA 10-6A1. Okay, now we're on the buyer brokerage agreement now. And in the buyer brokerage agreement, it talks about commission. Well, it gets a little wonky talking with a buyer about commission. And for some agents, they're a little hesitant to get a buyer to sign a buyer brokerage agreement because they're not quite sure how to have this discussion about commission that's spelled out in the buyer brokerage agreement. So let's go over it. It states that the buyer agrees that the broker is entitled. It doesn't say in paragraph 8 that the buyer is paying. It says the broker is entitled to the commission at the closing of a transaction, a certain percent of the sale price or a flat fee. Paragraph B says, in the event that the seller does not pay the broker the full amount of commission that you had listed over in paragraph A, the buyer shall or shall not pay the broker the difference at closing between the broker's commission and the commission actually paid. So you fill that part in. Let me just skip to this section here. Under the commission, and this is the corresponding paragraph, B5 of the brokerage agreement, it says that, see where it says paragraph A is what I just described. Well, it also says that if there's a bonus, the broker / agent is also entitled to the bonus, even though it wasn't referenced under the commission. But look here in paragraph B, while not required, the custom in Georgia is for the seller to pay the commission of the real estate brokers. And we just went over that in depth in the listing agreement. So what this is talking about is if the listing broker does not pay the selling broker, whatever number is here, then you negotiate with the buyer shall or shall not pay the difference. All right. Then it talks about the exclusive agreement. This says buyer warrants that the buyer is not a party to another exclusive buyer brokerage agreement, and any agreement to terminate this agreement or any other subsequent agreement must be done in writing and signed by the parties. So this gets a little crazy. Sometimes in this market, you might have a buyer that approaches you and says, I heard wonderful things about you. I want you to represent me as a buyer to help me buy a house. And you say, well, are you working with another agent? And they say, well, I was, but I fired my previous agent. Well, oh my goodness, what on earth does that mean? What does it mean if they fired their previous agent? Does that mean that they stopped communicating with them? Does that mean they sent them a text message? Does that mean that they signed a unilateral termination agreement of a buyer brokerage agreement? Does that mean they signed a mutual termination of the buyer brokerage agreement? We have no idea what that means. License laws in Georgia state they will tell you what to do and how you need to approach it if a buyer approaches you and says they fired their previous agent. Again, these are laws that are spelled out in the Beretta laws, OCGA 10-6A. as well as in our unfair trade practice laws, OCGA 434025. And basically what the laws say, if you have reason to believe a buyer or seller may have an outstanding brokerage agreement with another broker, you need to confirm with that previous broker that the person has terminated that agreement with the previous broker prior to signing with you a brokerage agreement with you. So if they say they fired their previous agent, that absolutely gives you reason to believe they had a may have an outstanding brokerage agreement. So there is specific verbiage that you need to use. And again, this is a whole nother 30-minute discussion. But I have done a video on this and the verbiage to use to include to keep yourself in compliance with license law is all spelled out with links to the actual verbiage in the YouTube video on the channel Real Estate Made Crystal Clear, all about the protected period in the buyer brokerage agreement. So we talked about the protected period in the listing agreement and in the buyer brokerage agreement, and it discusses this also regarding how to proceed if a buyer says they fired their previous agent. Okay, talk about commission. We talked about this a little bit where it talks about the seller is generally speaking the one who pays the commission in the state of Georgia. And even though you don't reference a bonus in the buyer brokerage agreement, you are still entitled to, your selling broker is entitled to the bonus on a particular transaction. Now, what about a FSBO? If the buyer purchases a property being sold by owner and the owner is unwilling to pay the broker its commission, as we talked about in the authorization to show unlisted property, the buyer agrees to pay the broker its commission at or before closing. And then it talks about buyer default. That buyer owes commission, whatever you had agreed to in that previous paragraph, if the buyer defaults on the contract. Now, let's talk about the protected period in the buyer brokerage agreement. In the buyer brokerage agreement, the selling broker's commission is protected, again, for whatever time frame after this buyer brokerage agreement expires or terminates, for whatever number of days you negotiated. For a buyer who was introduced to the property during the term of the buyer brokerage agreement. Again, it's vague. GAR leaves it vague, but the intent is if you showed a property, wrote an offer, discussed it, not just, again, that your buyer saw it through an automated program. Now, if you have a buyer brokerage agreement in the RE forms, the protection period, you are only protected if you specifically list properties that were seen during this property. And in the RE form listing agreement, you have to specifically identify potential buyers that saw the property while it was listed. And again, time is extended if the, okay, well, before I get to that, there is nothing in here about the buyer signing an exclusive buyer brokerage agreement with another broker. So the whole thing that caused eyes opening under the listing agreement protection period, that is not true for the buyer protection period. So point of practice, if the buyer does sign with another broker, that's why that license law is in place, that if you have reason to believe that they were working with another broker, you need to confirm with that other broker that they in fact are no longer working with that other broker under a buyer brokerage agreement. Now, if you are the former broker, you probably want to make sure to protect whatever properties you showed that buyer to if you want commission on that, because your commission would be protected if that buyer buys a property that you showed to them or wrote an offer on them during your buyer brokerage agreement. So again, that protection is in place if the buyer signs another buyer brokerage agreement. So if you are buyer's agent number 2, basically your commission is fully protected for a property that you show the buyer from that point forward or bring to the attention of the buyer, not anything that the buyer had previously seen with buyer's agent number 1. All right, if buyer submitted a letter to be released, does that cover anything? Broker released by confirmation. Again, those brokerage termination agreements that we covered earlier, those are brokerage termination agreements for either a listing brokerage agreement or a buyer brokerage agreement. So it depends if the parties are terminating unilaterally or terminating mutually. If you are terminating mutually, then all the fees are spelled out in. Okay, so in the buyer brokerage agreement, the buyer's duties, again, they are to work exclusively with you, disclose if they've worked with anybody else, and it says they are not to see any for sale by owners without notifying you. All right, then there are all kinds of disclaimers and disclosures that are designed to protect you, where it talks about limit on broker's authority. And basically, this question has come up. It specifically states that the broker may work with other buyers to see property. And again, it's the buyer's responsibility to investigate anything of concern to them regarding the contract or the area. For example, get a survey, check the zoning, check for flood insurance, check the school district. Point of practice, you guys, use the consumer brochures and get their signature on the service recommendations. I'll cover that in 2 seconds. But it's come up, especially in this fast market right now, a lot of agents are working with more than one buyer at a time, and there is a property that comes on the market that is of interest to 2 separate buyers with whom they are working. When your buyer signs the buyer brokerage agreement, you are disclosing to them that you may show the property to other buyers. So you do not have to disclose to each buyer with whom you are working that you are showing another one of your buyers. You have a duty to work in the best interest of both buyers to get that property, because each buyer has a unique set of circumstances. But that is spelled out in paragraph C4 through 6 of the buyer brokerage agreement. Now, service recommendations. You guys, nothing is an issue until it's an issue. But yes, it could be awkward, and you absolutely would probably want to check if your broker has a policy on that, because your broker might have a policy on what to do. But I just want to let you know where it is spelled out in the buyer brokerage agreement. Now, nothing's an issue until it's an issue. You do not want to get after closing and your buyer come back and say, gosh, I thought the property was bigger. Gosh, I thought that third driveway was actually part of my property, only to find out it's not. Gosh, I didn't know I should have checked for radon. Oh my goodness, my homeowner's insurance people came to me and said, I now need flood insurance. I didn't know anything about that. You guys, prevent all of this stuff in advance. We provide a form at Maximum One, and I am more than happy to share it with anybody taking this class. There is a copy of a handout for you where I have the handouts. Please, if you are not a Maximum One agent, please make sure to get permission from your broker before using any forms. But basically, it is called service recommendations, and it says that it is professionally recommended that purchasing a home, you should basically have it checked out, because Georgia is a caveat emptor state, and the burden is on the buyer to make sure they are satisfied with the contract. So you would fill in the property address, and it says, I choose to get a Georgia wood infestation clearance letter and bond, yes or no? Inspected by an independent home inspector of my choice, yes or no? I choose to get a home warranty. I choose to have the roof inspected. I choose to have it inspected for radon by an inspector company of my choice. I choose to have it inspected for mold. I choose to have it inspected for lead-based paint. Asbestos. Get a survey. Get owner's title insurance. Review the CCRs. Check, confirm current zoning and any imminent changes. Confirm any proposed changes to property lines, eminent domain, utility easements, hazard insurance, flood insurance. can I park large vehicles like RVs or work trucks? School district, wildlife, so are there any leases on the property? So forth and so on. Then there is an indemnity and hold harmless language, and then your client signs it. So they are checking yes or no. This will protect you after the fact because it will demonstrate to a judge or arbitrator that you, in fact, had these discussions with your buyer. You guys have this discussion with your buyer at the time you sign a buyer brokerage agreement, before they go under contract, before the end of their due diligence period, not after, because these things might help them make the determination if they're going to continue with the contract or terminate within the due diligence period and protect their earnest money. But after you close, when these issues come up, is not the time to have that discussion. Now, buyer as a customer. If they want to work with you as a customer, again, the GAR form is F-116, agreement to work with buyer as a customer. And it specifically states that they shall only be working with the buyer as a customer, and you can only perform ministerial tasks on behalf of the buyer. There is, again, I'm not going to cover this in class, but I want to let you know when you download the handouts for your reference, all of this is spelled out. I have OCGA, again, Beretta laws. It has the legal definitions, responsibilities to a seller client, responsibilities to a buyer client, and responsibilities to customers, and responsibilities as a transaction broker. I also have as a handout copies of these PowerPoint slides. Again, I'm not going over this, but a lot of agents will ask, well, what does that mean? What does it mean if they're my client? What can I do versus what I do when I am performing ministerial acts? These next slides, and again, I have this, you can read it as a handout, describe what you can do when you are working with the public as a client or as a customer or as a transaction broker. And basically, ministerial acts, this is what describes. You have to be, in any situation, you have to be open, honest, not misleading, and not discriminatory. But this specifically describes what ministerial acts are. And this describes what transaction brokerage is. So let's take a break. What do you think? Let me stop the share. All right, I've got 10:55. Let's come back at 10 minutes after 11, and we will continue back. I will stay on to answer any questions for anybody, but let's take a small break and come back at 10 minutes after 11. Feel free to ask me any questions in the chat, or if you want to unmute yourself, you can ask me a question verbally. All right, everybody, see you in 15 minutes.
Dana?
Yes?
Hi, this is Carol Little. I'm having an issue when I go into chat. It does
come up, and my broker had no clue, and I even called Seth Weissman, and he had no clue, so I thought I'd see what your opinion was.
Okay.
So let's say I'm showing a property to 5 different clients, which this actually did happen. Same
Okay.
property, 5 clients. And 4 of them I ended up writing offers for.
Okay.
Do I have to disclose my relationship with the other 4 to each one?
My answer per what we just discussed in the buyer brokerage agreement is no, absolutely not. The buyer, so you're a buyer, you have buyer brokerage agreement signed with all 5 or all 4 of those buyers.
All 5, correct.
All 5. Okay. So the buyer brokerage agreement specifically states when each buyer signed a buyer brokerage agreement with you, it states that you are disclosing and they acknowledge that you are showing properties to other buyers.
So even though that says that, what I opted to do, and my broker and Weissman all agreed, was even though we didn't have to, I went ahead and disclosed it anyway, because I didn't want there to be an issue that came up later if one of them got it and the others didn't, that one of the others said he wasn't working for me as hard as he was for that one, or he likes that one better and that's why he negotiated better, or something like that.
Well, here's the thing. The thing is, again, as I mentioned, you definitely want to check with your broker to see if your broker has a policy on any kinds of disclosures. The other thing that I always say in everything is, well, it doesn't necessarily apply to this, so I'm going to keep that. But you could be in a pickle, and nothing's an issue until it's an issue. So do you have to? According to the buyer brokerage agreement, they already have acknowledged that, and you've already disclosed that. According to, would you want to know, or to avoid any, nothing's an issue till it's an issue? Yes, it probably would be it probably would be an absolutely good practice to disclose it to the others. And I would go further than that. Andy, I would give any one of those buyers the opportunity to work with another broker for that particular contract. And when doing that, I would negotiate a referral fee with the other broker.
Yeah, the way this one came up was weird. It's another agent who works for another office is a friend of mine, and he had the listing, and it's a bankruptcy. So he was getting inundated with calls, and he said, here, just take some of these and get them off my plate. And I ended up getting exclusive buyer brokerage agreements with 5 of them. And then I just went out to the house. I had all of them meet me within about a 20-minute period, and they all had me write offers.
So, and that happens in the fast market. That was a prevalent practice, Andy, during the foreclosure market too.
Mm-hmm.
Now, generally speaking, not every buyer is the same. Not everybody has the same qualification. Not everybody has the same desires that they're looking for. You know, not everybody, you know, so each buyer has their own unique set of issues that they're looking for in a property. But again, like for example, we know the laws on dual agency. The license laws on dual agency is that it's not illegal, but you must have written consent, written disclosure, and written consent by both parties. Now, even in a designated agency situation, not designated agency. There are situations where you have both sides of a deal, but it's not dual agency. For example, let's say you have a listing, so you have a listing agreement signed, client relationship with the seller, you get a signed call, that buyer loves the property, wants to buy it. You work with the buyer as a customer, they sign an acknowledgement to work with the customer, you already have a client relationship with the seller, you write the contract. So you have both sides of the deal. It's not dual agency, but you have both sides. There's nothing in law that says, well, the contracts, the GAR and the RE forms contracts disclose dual agency anyway. But there has been I have been involved in a GREC investigation where an agent did have both sides like that. It was not a violation of dual agency. The brokerage did not have a policy against dual agency. One of the questions that the GREC investigators asked is, did you, the agent, disclose to both parties your relationship with each of the parties and get written permission to proceed? So the GREC investigators asked, in essence, did the agent follow the same procedures that they would have had it been a dual agency situation, even for having both sides? And thank goodness the agent was able to demonstrate in writing that they had that discussion about working with both parties. So again, per the contract, per license law, is there anything requiring that? No. Is it good business practice? Absolutely yes. So that's my answer. I'm sticking to it.
Well, thank you.
My pleasure. Thank you.
It's funny how every time I'm in one of these, I always have the most complicated question somehow.
Keeps me on my toes. Anybody else have any other questions?
Well, Dana, in that scenario that was just presented, you know, if I'm one of the buyers, and I'm going to be interested in how competitive the offers are. So where does the agent fall in that situation?
Okay, great question. So if you are, if if you are an agent and you are working with 2 or more buyers writing offers on the same property,
Mhm.
you absolutely cannot disclose what each offer is.
Right.
And that's not
Mhm.
as often a situation. That situation does happen, but not quite as often as another situation. So
So
let's say,
why would I be obligated to just disclose that there are other offers? Why wouldn't I just treat them all fairly and move forward? Because if I'm in that scenario, my question would, I would definitely be inquiring as to how to make a better offer.
well, okay, so 2 things. We were talking about before, if you're an agent and you have 2 buyers, and
Right.
again, that's not as often, and you are not obligated to disclose that. We're saying it's probably good business practice. You need to check with your broker, but
Mhm.
that's not required per license law or per the contract, because the contract already discloses that the buyer agrees you can work with other buyers. Well, obviously, if a house is for sale, there's going to be more than one buyer that's going to look for the house.
Yeah.
So what happens more often is if you are a listing agent, I get this question a lot. If you are a listing agent and you get multiple offers, the question is, can you disclose what the nature of those other offers to all the buyer's agents that have offers? You're a
Okay.
buyer's agent. You're saying, hey, tell me what the highest offer is, listing agent, that you have right now. My buyer wants
Right.
this house. I want to beat it. The answer, okay, what do you think? Those of you that are on, and I know we're on the break, but
Mhm.
those of you that are on, can a listing agent disclose, in a listing agent with multiple offers on a property, can a listing agent disclose to the buyer's agents the nature of the offers they have on the table?
But they do.
Well, I'm asking you contractually and license law wise, can they? No,
Okay.
no, yes. No, I don't think so. The answer is yes, they can. Yes, ... The answer is yes. Yes, Jennifer is correct. Ding, ding. Jennifer, you get the gold star. If you have written permission from the seller to disclose the offers that are on the table. Now, you cannot disclose, now you're not going to give them the offers, but you can disclose the nature of the offers. Highest price I have right now is $375 with 0 closing costs. You can disclose that if your seller has given you written permission to do that. Now, you can't disclose anything that would reveal the identity of the other offers, the buyers, or the identity of the potential buyers on those offers. But if you have written permission from your seller, absolutely. Why not? Why wouldn't you be able to? You guys, think about any auctions,
Right.
not real estate related. Think about an auction that you've seen on TV, whether it be an auction for the sale of a car, whether it be an auction for livestock, whether
Sure.
it be an auction, some of you guys in different clubs or events or fundraisers that you go to for school or clubs or whatever, they'll have a live auction for, goods, people donate goods, they have a live auction to raise money. You hear what the other bids are. Don't art auctions.
Mhm.
You hear what the other bids are. It's in the best interest of the seller. Why is it so taboo in real
Right.
estate to not let other buyers know what the offers are? My goodness.
I can tell you why. I
Why?
can tell you why people are afraid to.
Okay, why?
So before I was in real estate, I was in engineering, and we had all these, contracts and bids, and we would bid against other companies for jobs. Well, in Georgia, bid shopping is horribly illegal, and that borders on bid shopping. So if somebody says, hey, I'm looking to put in an offer, I was thinking about doing this much, would that be competitive? And if the seller says, okay, then sure, that's one thing. But if, say, you get 6 offers and you call each of those people and you say, well, so my last highest offer was this, do you want to beat that? Then that's bid shopping, and that's illegal.
Well, and that's interesting because I'm not familiar with that. But in so we're not talking about, let's say you get an offer, let's say you're a listing agent, you get an offer, you only have one offer. I can absolutely see how that applies if you call, you know, somebody that just showed it and say, hey, I got an offer of this, do you want to beat it? Totally, I can see that. But in a situation where you have multiple offers, again, you have anything I'm saying, you guys, you've got to check with your own broker. Make sure your broker does not have a policy against it. If you have your seller's written permission, then you can do it. But again, you may not want to do that. You may want to just go back, which is typically what we see with asking for a highest and best. You buyer's agents, I'm telling you right now, this is a fast market. Properties are selling with multiple offers, as long as the property is priced appropriately for the condition and the location. Your buyers should be making their highest and best offer with every initial offer they're doing.
Testing.
Now, we hear you, Sandra. So there's another tactic that your buyers can use in their offer if they are aware of the fact that it is a highest and best situation. And generally speaking, that is what happens is a listing agent will call for highest and best. And Andy, thank you so much. I appreciate that. I was not aware of that law, and I'll have to look more into that specifically to real property, but I absolutely appreciate that knowledge, that information. There is what's called an escalation clause, and I will cover that when we get to the special stipulations portion of this class. So a lot of times there is a buyer will write an offer with an escalation clause if this is the property that the buyer really, really wants. And again, I'll cover that specifically. And that's a great way to help your buyer come back and potentially get that property. All right. Did that help, Tim?
Yeah, I think so.
It either helped or made things more confusing.
Yeah, well, I know bid rigging, that's more associated with government contracts. But I do understand. And then another question for you. Can you answer a question quickly?
Sure.
You have time? Okay.
Yes.
And I know you went over it briefly as far as agent approaching a FSBO and the owner not wanting to list the property. There was some specific agreements that we need to utilize in order to secure the sale. What is the procedure to complete the transaction and get your commission after the sale of the property without listing it? They don't want to list it, but you do have a buyer.
Gotcha. So what you would do is you would have that seller sign the authorization to show unlisted property, where it talks about commission. The seller agrees to pay commission. Then so I'm assuming you've already signed a buyer brokerage agreement with the buyer. So you're working with the buyer as a client, and the seller agrees to pay, the seller signs the authorization to show unlisted property and agrees to pay commission. You sign the purchase and sale agreement. On the bottom of the purchase and sale agreement, there's an agency relationship section that you fill in. So you would say, ABC Realty is working with seller as customer. ABC Realty is working with buyer as client. Then on the signature page, buyer's going to sign, seller's going to sign. Under the brokerage section, you are going to sign, you're going to fill out the brokerage section on both sides, and you as the agent are going to sign both sides of the purchase and sale agreement. But the disclosure regarding the legal relationship between that public person and your broker is described on the first page of the purchase and sale agreement.
Okay.
That answer?
Yes, it's very helpful. Thank you.
You're welcome.
Yeah, it's been a while, maybe 10, 15 years. So,
welcome back.
Yes.
All right. Any other questions?
Yes, I have a question, Dana. I don't remember how you said we could get a copy of the handouts from today.
I'm going to show everybody that in just a second.
Okay, great. Thank you.
All right. All right. So welcome back, everybody. Well, we've covered a lot, and we are going to go through the rest. We go till 12:30, so we've got an hour and 15 minutes. and we will get it all done. But I spend a lot of time on the brokerage agreements because that's really where everything everything starts off. So let me show you guys. I'm going to share my screen again. Okay, let me put it in the chat one more time. And now let me share my screen and show you guys where you guys can get the handouts. So give me 1 second. All right. Let me get out of this. Okay, so you're going to go online and you are going to go to www.eagentweb.com. No password, no anything. You just type in eagentweb.com. On this website, you are going to click here where it says training videos. And then you are going to scroll down and you will see copies of the CE classes that we have taught through the Georgia Real Estate Academy. So here's the last one. Here's today's class, Weird Contract Forms with the correct course number. I'm the instructor. There's my email address. There's the notice to students. I am recording this, depending on if the technical difficulties didn't prevent that from happening. Here are the handouts. So for example, if you click on this, handout 0, that is a PDF of the slideshow. So you click on that and you get all of the slides that I'm going through. Let's go back here. Here is a PDF of the exclusive seller listing agreement. You click on that, you get a PDF of the entire listing agreement with all of my notes already in there, things already underlined. When I teach this class in person, you get copies of these handouts. It's obviously a bit more challenging teaching it through Zoom. I had to copy and paste, but I wanted to make these handouts available to you. So everything we've been discussing is on those handouts. Then we'll go back here, and there's the buyer brokerage agreement. Here's the unilateral termination of the brokerage agreement. Here is the mutual termination of the brokerage agreement, and this says brokerage agreement. So you would use this to terminate either the buyer brokerage or the listing agreement. Go back here. Oh, shoot. Let me refresh. And anyway, here are all the handouts. There are 23 handouts, but they are all underlined, and here, that form service recommendations, I have that here for you guys. Again, please check with your own broker prior to using any form you receive in class. But all of the handouts I'm mentioning are available to you. So you just go there, you're going to click on a handout, and then it pops up as a PDF, and you can download it to your own computer. And then we have other classes, all the classes that I've had the opportunity to record or that have handouts associated with them. You are more than welcome to scroll through, and you are more than welcome to any of the handouts if you want to use those for your own reference. Here's a class that I taught on the 2020 RE contract forms dissection. And again, it's got all the handouts with all my underlines and all my notes. So I hope that helped. Additionally, while I'm here, eagentweb.com, if you click here on this tile that says calendar, if you go to Marietta, again, things are a little different since we're teaching classes virtually, but if you click on Marietta, you will get the training calendar, and all the classes in orange are the CE classes, and they are all virtual. So this is the master calendar for all the virtual classes, and you can skip ahead to September, and our September calendar is posted. So if you see anything you like virtually that you want to take, you would just click on it, and it takes you to the registration. You click on it and you can register. I'm teaching a fair housing class the end of September. So while we were there, I just wanted to go ahead and show you that. So I hope that helped everybody for the chat. It's fun seeing smiling faces. All right. Now, Again, welcome back. Please type in your name, email address, and your license number. If you are attending by phone, please also type in your phone number, and please be responsive with the chat. That's how we make sure that you're there and paying attention. But this is so amazing stuff, right? How could you not be paying attention? So, like any CE class, we have a course evaluation that we need for Greg. Obviously, I can't hand it out in person, so I have a poll that I am going to launch. So we do an electronic poll. It is anonymous, just like when you get a course evaluation in class. When you see it, it's going to pop up on your screen. There are 4 questions. You need to answer all 4 questions, and then you can hit submit. So after you hit submit, it will go away. So I am going to launch the poll. And again, you will see CE course evaluation, a total of 4 questions pop up on your screen. There's only typically 2 or 3 that show at a time. And as you answer, you have to scroll through to get to all 4 questions. And after you get to all 4 questions, that blue submit button lights up blue. You click that and your answers are submitted. If you have technical difficulties with it, don't worry about it. You can get this out of your way by clicking the X or the little minus sign at the top. I cannot relaunch the poll because I lose all the questions. So anyway, just wanted to share that with you. I am going to put everyone on mute again, and we're going to go back, okay? All right, everybody. Here we go. Let me share my screen again. And we'll go back to the presentation. All right. Hopefully my computer will stay connected to the internet. I think with so many schools doing online classes, I think the bandwidth of the internet lines throughout the entire state or world are definitely being challenged right now. Okay, so I am not in this class going to cover the financing forms, the appraisal forms, because we cover those in depth in the actual contract dissection classes. I just wanted to share this slide with you so you get the form number, but I am not covering these or we would be here even longer. I am also not going to cover the seller's property disclosure form or the community association disclosure form. We cover those in depth in the contract dissection classes. But we are going to move on to some other contingency exhibits. So here we go. All right, sale or lease of property contingency exhibit. This is GAR form F601. So this is a situation where a buyer wants to buy a new house, but they currently live in existing house. And they have to sell or get a lease on existing house before they are able to go through with the sale of new house. Now, there are 2 kinds of buyers. There are buyers that, gosh, I absolutely cannot afford both mortgages. I can't afford for a mortgage to continue to pay the mortgage on my current home and the mortgage on my new home. I won't qualify for the new home unless I get rid of the mortgage on my current home. So I can't go through with it unless my current home sells. There's another buyer that says, gosh, I can qualify for the new home. I can handle both mortgages for a short period of time. I just don't want to. So it depends on the situation of your buyer as to the relationship with this contingency exhibit. But nevertheless, basically what you're going to do is the buyer warrants that they own property and you fill in the date. You fill in the property address, and then it says you fill in what steps they're doing to actually sell or lease the current property. For example, home is currently listed. Home is currently under contract. Home is under contract and we are past due diligence period. Whatever steps the buyer has taken with regards to eliminating this contingency to go through with the purchase of the new home. Now, you have to fill in the date. Don't leave this blank. I don't know why we see this blank on a lot of contingency exhibits, but you have to fill it in. Okay, for the contract dissection classes, I don't recall off the top of my head. You'll have to look at the calendar like I just showed you. So you have to fill in a date, and that date is the contingency time frame period. And it's either contingent on the buyer closing on the sale of their other property or entering into a lease. Most often we see that a buyer has to close on their current property. Now, look at paragraph C. This is very important. In the event this contingency period ends without the contingency reference above being fulfilled, in other words, the buyer doesn't sell their property or they don't get a fully executed lease, then at that time, this agreement to buy the new home shall terminate. So if the seller, if the buyer has this contingency exhibit and the buyer does not sell their current home, the contract for the new home automatically terminates and the buyer's earnest money will be protected because they did not meet the contingency in the time frame that the buyer and seller agreed upon. Now, the buyer can always remove this contingency themselves and say, nope, guess what? My circumstances have changed. I want to proceed with the sale of the new home. I'm removing this contingency. It doesn't matter what happens with my current home. All right, the next part of this is the kickout clause. So basically, a seller's like, okay, buyer, I'll take your contract. I understand that you have to sell your current home, but the only way I'm going to take your contract over another contract is if we include the kickout clause. And basically what the kickout clause means is, okay, in order for me to take your contract, you have to allow me the opportunity to continue to market my home for sale. And if I find another buyer that I want to go under contract with, then I first have to come back to you because I'm under contract with you. There's just buyer number 2 that I really want to go under contract with. But I come back to you and I give you the opportunity to either stay in contract with me and buy my house, or you are kicked out of this contract. I'll give you your earnest money back and I'm going to go proceed with buyer number 2. Now, you listing agents, point of practice. If you are under contract with buyer number 1 with a kickout provision, do not exercise the kickout to buyer number 1 until you fully negotiate a contract with buyer number 2. Go binding on that contract with a backup contingency exhibit that we'll talk about next. If you just have an offer and you kick out buyer number 1 and they terminate, and you never get terms negotiated with buyer number 2, you are back at square one, my friend. So that is just a point of practice. Now, let's see what's involved with the actual kickout. The actual kickout in the transaction, it can either be subject to a kickout or not subject to a kickout. So let's look at option number 2 first. This agreement is not subject to a kickout. That means seller agrees to go under contract with buyer. Buyer says, I can't buy your house. I can't close on your house until I sell my house. My contract with you is contingent on mine selling. Without a kickout, that means nothing seller can do. The seller is at the mercy of whatever happens with the buyer selling their current home. That obviously is better for the buyer. What's better for the seller is to have the kickout that we just described. So if the contract is subject to a kickout, then up here you fill in the number of hours and you can negotiate for additional earnest money or not. So basically, seller gets offer, or in what I suggest, has negotiated, goes binding with a backup clause with buyer number 2. Then you go to buyer number 1 and you say, okay, buyer number 1, you have 48 hours, 72 hours, 24 hours, whatever number gets negotiated here. After you get that notice that I want to kick you out, to let me know if you are going to go through with the contract or if you're going to terminate and get your earnest money back. If you are going to go through with the contract, then there are certain other contingencies that are going to be removed. And these contingencies get negotiated in this exhibit. You're going to remove the sale or lease of buyer's property contingency. You're going to remove the due diligence period if that's still intact. You're going to remove any financing contingency. You're going to remove any appraisal contingency, any special stipulation. So this gets negotiated in advance. So this first one, sale or lease of buyer's property contingency, that second buyer, that, look, I can afford both mortgages, I just don't want to. That might be the option if you have that second buyer who still wants new house and they're just going to be willing to carry 2 mortgages for a short time. If you have buyer number 1 and they, depending on how far along you are, you might not be able to remove that contingency, or there can be a blanket removal of all contingencies. So that's how that form works. Now, if the seller sends the notice that they're kicking out the buyer, and the buyer either has to send an amendment saying, yep, we're gonna remove these contingencies and stay in contract with you. If the buyer doesn't send that amendment indicating they're going to stay in contract with the seller, then it is then the contract terminates and the buyer gets their earnest money back. And then the seller moves on to the contract with buyer number 2. Okay, now let's move on. How do you continue to market a property binding in FMLS? FMLS and Georgia MLS have a status where it says active with kickout. I believe that's the verbiage. But there is a specific status in at least FMLS and Georgia MLS. I'm not as familiar with the other MLS services, but it does indicate that, like I said, active with kickout, something to that.
It's active under contract.
Active under contract. Thank you. Okay, so back up, and you buyers agents, if you guys are working with buyers and you can't find properties, you definitely want to search that status, not just active, but active under contract. Okay, moving on to the backup contingency exhibit. So basically, this is an exhibit to a binding contract so that the seller and buyer number 2 actually have a binding contract. And just like any binding contract, it is binding when the buyer and the seller agree and notice of acceptance is given. So the first thing that is in this backup contingency exhibit is you have to identify the names of the primary buyers. So there is only one binding backup contract because you only have one primary contract. So what that means is if you're a buyer's agent and you call a listing agent and they're under contract and the listing agent says, yeah, I'm under contract and I've got 5 backups. That's just not true. They might have 5 other interested buyers, but you can only have one binding backup contract because you have to reference the primary contract. So this is a form you use, again, when you fully negotiate the contract and you go binding. And the binding agreement date is the binding agreement date of any contract when the buyer and the seller agree and notice of acceptance is delivered. But what about the dates for everything else? Well, in paragraph 5 of this backup contingency exhibit, it says that if the primary contract is terminated, because again, we're buyer number 2 in this situation, the seller sends notice to buyer number 2 that, guess what? Primary has been terminated. You're no longer in backup position. You are now primary contract. As soon as buyer number 2 gets that notice that they are now primary, that is the date, or day 0 for counting purposes, for all the other contingencies. So for example, if it says due diligence is for 10 days, that date of that notice is day 0, and due diligence extends for 10 days beyond that in my example. However, earnest money is delivered whenever this went binding with the backup contingency exhibit per the purchase and sale agreement, just like earnest money is handled in any purchase and sale agreement. Now, if the buyer and the seller want to negotiate that this date of delivery of notice that they become primary is also the timing for earnest money, you must add that as a special stipulation. But without that as a special stipulation, the earnest money deposit is due, the earnest money remittance from the buyer is due just like any other contract from the time buyer and seller sign and give notice. All right, any questions on that? Okay, moving along, temporary occupancy agreement. Oh, I'm moving fast. I'm moving faster than I thought. Temporary occupancy agreement for the seller after closing. So nowadays, okay, I'm going to tell you guys as a broker, and you guys have lots of experience with this as an agent. The ideal way to sell property is at closing, the property in question is vacant. In practicality, is that always possible? Not necessarily. But sometimes that can be very, very tricky to deal with. It becomes tricky for a variety of reasons. It becomes tricky, especially if the seller is also buying another property. So you have multiple transactions or domino transactions that have to happen. Because what happens is, let's say you have a buyer and the buyer is buying house number one. Seller of house number one is buying house number two and has a contract on that. So let's say your contract is closing September 5th. Seller's contract for the house they are purchasing is closing September 6th or even the same day, whatever. So the seller wants to stay in their current home until they close on their new home because they have nowhere to go, right? So you'll say, fine, I will give you occupancy to stay in there for 2 days. What happens if the seller, something happens with their loan, or let's say, let's just say something happens with their loan. They can't close on their new house, house number two, for sometime after September 6th. Well, what happens if the seller doesn't vacate this house that the buyer now owns? So it can be very, 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 very tricky. Hopefully everything falls into place, but it can be very tricky. So you absolutely, if this buyer is going to grant the seller the privilege of staying in the buyer's home that they will own after closing for a certain time frame after closing, you absolutely need a temporary occupancy agreement. Now, this is just an agreement to the contract. It's not a lease. It can't be for more than 60 days. If it's going to be for more than 60 days, then you need a lease. And the reason it's not a lease is because if there is a lease in place, a couple things happen. Number one, the buyer's loan all of a sudden may not be an owner-occupant loan, but may be perceived as an investor loan. So that's a complete different loan scenario and qualification, interest rate and down payment requirements if it's an investor loan versus an owner-occupant loan. Number two is there are all sorts of additional laws that kick in pertaining to the contract. There are Georgia landlord-tenant laws that kick in where if it's not a lease, those don't kick in. That's why it can't be used for more than 60 days. So it's just an exhibit to the contract. And basically it says the seller has the right to occupy the property for X number of days after the closing is consummated. And at the time of closing, the seller has to give the buyer a set of keys, and the seller who's now in the property but they don't own it, they maintain all the utilities. Now, if the seller does not timely vacate the property by the end of the temporary occupancy period, the seller shall be deemed to be what's called a tenant at sufferance. It doesn't matter that there's not a lease. They are still considered legally a tenant at sufferance, which means they are unlawfully in that property after they were supposed to have been out. Guess what? If they don't vacate the property, guess what the buyer now has to do? Yep, the buyer now has to go start the eviction process. They have to go down to the magistrate court, file a writ of dispossessory, has to be heard. There's all sorts of stuff that has to do, but they would have to file eviction. But the seller says, that they will pay the buyer for however many number of days they stay in the property after the number of days that were negotiated for the temporary occupancy. Now, point of practice, you buyer's agents, the buyer will now own the property, but they can't move into the property. They're going to have to stay somewhere. So when you are filling in this for the holdover time frame for compensation, you definitely want to make sure that dollar amount is enough to cover the cost of a hotel, extended stay, Airbnb, wherever the buyer is staying for however many number of days, so that the buyer can get reimbursed for the time, the money they're going to have to spend for staying wherever they are staying. Schedule 2 closing, same day. Yep, 3-day settle. Yep, there's all kinds of issues, and it can be tricky. The question is, guess what? In the GAR temporary occupancy agreement, there's nothing in that agreement for the seller to pay the buyer for the privilege of staying in the buyer's new home after closing. However, all that's in there is the per diem for being a tenant at sufferance. And that's paid. Hopefully the seller will pay that. If not, you might have to go to court to get that paid. However, in the RE forms, occupancy agreement for seller after closing, it's RE form 255, there is a provision for a usage fee. And it says the seller shall pay the buyer at closing a fee in the amount of a lump sum or blank per month. I would suggest a lump sum because you're not going to do it for more than 60 days, beginning on blank and continuing thereafter until the end of the occupancy agreement. I would have, seller shall pay buyer at closing. Guess what? Your buyer gets this money at closing. This would be on the closing statement because this is an exhibit to the contract. So this would be on the closing statement, a credit from the seller to the buyer, or however the closing attorney is going to work it. But there is a compensation fee for the privilege of the seller staying in the property for however many number of days after closing. Now, in the RE form, there's also a per diem for compensation for a tenant at suffrage. But generally speaking, the GAR temporary occupancy agreement is better for sellers, and the RE form occupancy agreement is better for buyers. So what you can do is you can, I'm not telling you to plagiarize, but I'm telling you to confirm with your broker or closing attorney to use some sort of verbiage to this effect if you want to use the GAR form, but negotiate for a usage fee. I just wanted to bring that to you. Yes, it absolutely can get very tricky. And a lot of times what happens is, you know, and sometimes you just have sometimes you'll have a seller that just changes their mind and doesn't vacate. That's a whole nother issue. Sometimes you have a delay of a couple of days that they just can't get out. And sometimes it can negotiate, and I'm seeing in the comments, it gets negotiated with leaving other personal property items or financially, but it can be very tricky. All right, moving along. Amendment to address concerns with the property. This is GAR Form 704. So basically what this is, buyer and seller go under contract. There is a due diligence period of a certain number of days. The due diligence period is only a time frame for the buyer to decide, am I going to terminate this contract or am I going to go through with this contract? I can terminate for any or no reason. I don't have to give the seller a reason. I can just choose to terminate. if I do so and send notice prior to the end of my due diligence period. In order for me as a buyer to help me decide, am I going to stay in the contract or terminate, there's all sorts of things I can do. I can have the property inspected by an independent home inspector. I can have the property inspected by a roofer. I can have it checked out for termites. I can check the zoning. I can check for flood insurance. I can check for traffic. Am I going to be able to make a left turn out of my subdivision crossing traffic during rush hour? Is there any road improvements planned? What's that big building, that big land that they're clearing 2 miles from my house? Is that going to be a shopping center? Is that going to be a new subdivision? Or is that going to be a water paper processing plant? So there's all kinds of things that a buyer is going to do during their due diligence time frame to determine. I'm going to have a survey done. I'm going to check it for radon. There's all kinds of things a buyer is going to do to help them make the decision to stay in the contract or terminate. Generally speaking, a buyer will have an independent home inspector inspect the house, and the buyer can propose an amendment to address concerns with the property to the seller and say, hey, seller, guess what? I am trying to make this decision. I found some things with the property, and I'm just curious, will you address these? Will you replace the rotten wood and repaint it around the windows? Will you replace this window where the seal has broken? Will you reverse the polarity in that GFCI outlet? Will you, these are things that really have to be done. I really don't want to spend the money on. I'm wondering if you'll do that or not. Will you replace the roof? Will you jack up the foundation because it has settled so much and the house is going to fall down? So there are things that a buyer just really doesn't want to spend money on, but they're not willing to throw out the contract for that. They would like for the seller to pay for it and do it, but they're not going to throw away the contract. There are other things that I like to call make it or break it issues that, hey, guess what? I really, really want this house, but I cannot afford to put a new roof on it if the seller doesn't replace the roof. I cannot afford to have a structural engineer come out here and jack up the house if the seller isn't willing to do it. I'm just not able to stay in contract, and I'm going to have to terminate. So during this time frame, there is all kinds of incentive for the seller to address these concerns. Not an obligation, but an incentive. Now, for the buyer, again, it depends on if it's little things or make it or break it issues. So the buyer and the seller can go back and forth and negotiate these items on this amendment to address concerns. If the buyer and the seller do not, okay, let me go back to due diligence period. If a buyer does not terminate the contract and send notice of that termination to the seller prior to the end of the due diligence period, the buyer has agreed to buy the property as is, okay? If they have sent an amendment to address concerns to the seller, but the seller hasn't signed it, doesn't matter. They either terminate before the end of due diligence or they're buying it as is. If the seller has not signed any of this, or let's say if the seller has, the buyer sends an amendment saying, okay, seller, I want you to do A, B, C, and D. Seller sends back a counter amendment to address concerns saying, I'll do A and B, but not C and D. Due diligence period comes and goes. Buyer, we're out of due diligence. Buyer then signs this and sends it back to seller. At that point, the seller is no longer obligated to perform those repairs. And basically, this was added in August of last year. It says, if this amendment does not become effective during the due diligence period, it shall become null and void and no longer full force and effect. In other words, there's no more incentive for the seller to do anything after the due diligence period if the buyer doesn't terminate. This is the only amendment in the GAR package that has a time limit. So in essence, the due diligence period is a time limit on this amendment. So that's what that means. And again, if the due diligence period ends without it being fully executed, buyer's buying it as is. Now, if the seller does agree, buyer sends over amendment to address concerns A, B, C, D. Seller says, sure, no problem, I'll do them. If the buyer does agree, you have the option of this, the buyer's due diligence period shall or shall not terminate upon buyer's address. So if the buyer and seller get this fully negotiated before the contractual due diligence time frame, if this is marked shall, that does end the end of due diligence period. Now, what if it is a make it or break it issue for the buyer, like the roof or the foundation, and the seller, it's supposed to be sketchy. Communication with the seller is sketchy. You're not hearing back. Well, oh my goodness, what are you going to do? You're coming to the end of your due diligence period. You have no clue if the seller's, you're on the last day of due diligence, you have no clue if the seller's going to replace the roof or not. If that's the situation, so if it's a make it or break it issue for the buyer, you absolutely want to include this special stipulation that says, in the event that a subsequent amendment to address concerns is not accepted by the seller and delivered back to the buyer prior to the end of the buyer's right to terminate or due diligence period, then the amendment to address concerns shall serve as notice of termination as set forth, and they'll get the earnest money back. In other words, if a buyer, if it's a make it, so you guys, you only want this stip if it's going to be a make it or break it issue. If a buyer sends the amendment to address concerns, you don't hear back from the seller, and you've included this verbiage, then that does act as your termination, unilateral notice of termination prior to the expiration of the buyer's, of that termination period, and your buyer's earnest money will be protected. Now, I'm going to come back to repairs a little bit later when we come to special steps. All right, moving along, amendment to change the closing date. I just want to bring to your attention that in the GAR purchase and sale agreement, there is a right for the buyer or the seller to unilaterally extend the closing for 8 days. Now, there are certain provisions that has to happen, and that's addressed in the contract. On an amendment to change the closing date, this is a section in there. You can negotiate if you are changing the closing date by agreement, by amendment. You can negotiate if that 8-day unilateral right to extend is still in effect or is terminated. So make sure you pay attention to that. Generally speaking, if you have to extend the closing date, you want to do it by amendment as often as possible and use the 8-day unilateral as a last-ditch effort, because it can only be used one time per contract. Not one time per side, but one time per contract. All right, amendment to reduce the sale price. In the event the amendment to the sale price, so basically this is an amendment you're going to use if the buyer and the seller agree to negotiate a new sale price. So a lot of times, instead of an amendment to address concerns, buyer will say, look, I don't want you to fix anything because I know you're not going to fix it to my satisfaction, or it's not going to be fixed in a timely manner or whatever. So instead of you fixing stuff, I found a whole bunch of stuff. Instead of doing that, just change the sale price and give me a lower sale price, or negotiate in different closing costs. But if you are going to change the sale price, this would be the form that you use, amendment to reduce the sale price. Now, this form used to only be in pursuant to an appraisal. Now it's general. So generally speaking, this is what you would use to reduce the sale price. If, however, you are reducing the sale price because based on the appraisal contingency and the appraisal comes in low, then you must also send a copy of the appraisal, and you would negotiate if the appraisal contingency time frame terminates or not. Another point of practice, if you guys are lowering the sale, you can lower the sale price also just on a general amendment. But if you are lowering the sale price in lieu of repairs, just do an amendment stating the new sale price. You never want to put in lieu of repairs. Lenders do not like that, and that is going to send warning flags to the lender and the appraiser. So you just want to negotiate for the new sale price and never put in lieu of repairs. Now, agents can present that amendment to the other agent in their email. They can put in lieu of repairs, but you really don't want that on the amendment. COVID extension and special stipulations. I don't cover that in this class because that is a new recent issue timely right now. It is not a general issue, but GAR has sent out, and if you want to email me, I will share with you the GAR special stipulations, or you can just go to GAR's website. GAR has special stipulations regarding extensions in relation to a COVID-related event. Yes, okay, would it be preferable to just increase closing costs instead of dropping selling price? Well, there are a couple of issues. It depends. It depends on if the buyer wants a lower monthly payment throughout the course of their loan, or if they need more cash up front for closing costs or want to save their cash. So that could be something that gets negotiated. It typically does get negotiated either in, well, this is the 3 ways it gets negotiated financially instead of actually negotiating for repairs. It either gets negotiated in addition to closing costs. The thing you have to be careful of is the seller can only make a certain percentage of the sale price contribution to a buyer's closing costs. So you would have to check with the lender on that. Or it gets negotiated as a reduction in sale price. That also is going to affect the broker's commission. Or another way to handle it would be at closing, from seller's proceeds, seller to pay buyer of vendor's choice X amount of dollars. That way, especially depending on how far you are in the loan, that's not going to mess up the underwriting process for the loan. It doesn't impact the seller's percentage of contribution to the buyer, and it's just a seller from their proceeds, the closing attorney writing a check to a vendor from the seller's proceeds, handing that check to the buyer, so then the buyer can then schedule and take care of the repairs with the contractors that they have selected. Good question. All right. Other amendments. Again, there is a general amendment to the agreement. It's GAR F701. There is a general amendment to remove a contingency. That's GAR F707. There is the amendment to remove the sale or lease contingency. So we talked about that exhibit. If the buyer is going to stay, if the buyer gets kicked out, the buyer is going to stay in contract with the seller. They're going to remove those contingencies, and this is what they would use. They would use amendment to remove sale or lease contingency. It is GAR F719. And also in a lot of these contingencies, we read that the seller must send notice to the buyer. For example, in the sale or lease contingency, if the seller is going to invoke the kickout clause to buyer number 1, they have to send them notice that that's what they're doing. So you don't do it agent email to agent email. You must do it per notice, which has to be signed by the seller. So this is the form that you would use, notice, and it's GAR F816. All right. Whew. Any unilateral forms to extend closing date, just the 8-day unilateral. And again, that is only a provision in the GAR purchase and sale agreement. If buyer and seller are binding under the RE forms purchase and sale agreement, there is no provision for an 8-day unilateral extension. That's not law. That's just a contract issue. There's no 8-day unilateral in a HUD contract, in a new construction contract, in a Fannie Mae Freddie Mac contract. That is just a provision for the GAR purchase and sale agreement. And again, we cover those in depth in our contract dissection classes. All right. Moving along to earnest money forms. So we're going to talk about closing attorney acting as holder of earnest money. There is an exhibit to the contract, which is F110, and then there is an agreement that the closing attorney must sign. That's not an exhibit to the contract, and that's what the closing attorney must sign. Then we're going to talk about termination and releases. So closing attorney, do I have a copy of that? No. Closing attorney acting as holder of the earnest money. You guys, if you are going to have if the buyer and the seller agree to have a closing attorney as the holder, you absolutely must include GAR F5110. That is an exhibit to the contract. In the RE forms, there is nothing that the closing attorney signs agreeing to be holder of the earnest money. The closing attorney is not a party to the contract. They're named as a closing attorney, but there's nothing referencing them as the holder. So you have to include F5110 as an exhibit to the agreement. Buyer and seller sign that. And basically what that exhibit says is the buyer is responsible for delivering the contract to the closing attorney within 2 business days after the contract goes binding. Then the closing attorney must agree in writing by signing GAR F511 within 3 business days after receipt of the contract. If the closing attorney doesn't agree, then the alternate holder becomes the holder. The alternate holder must be named, and the alternate holder must be the listing or the selling broker. You guys, do not leave that blank, or you have all sorts of earnest money issues. Again, nothing's an issue till it's an issue, but if there's no holder of the earnest money and no one's sending notice if it hasn't been received, somebody's going to be upset. The seller's going to be upset if a buyer defaults and the seller wants those funds as liquidated damages. So you have to fill in the alternate holder. Now, if it is an all-cash transaction and the contract terminates and there's a dispute over the earnest money, in other words, buyer and seller don't both sign the agreement to terminate and disperse the, the agreement to disperse the earnest money. In an all-cash transaction, the only remedy for the closing attorney is to interplead those funds into a court. The closing attorney in an all-cash transaction, if they are a holder, may not interpret the contract and send a 10-day letter like a broker holder can do. There are fees and costs associated with a holder interpleading the funds into a court, and those get subtracted from the earnest money that is on hold. Again, the form F511 basically is a reiteration of everything that's in this exhibit, only it's the closing attorney that signs that and agrees to perform and fulfill all the responsibilities as the holder. All right, unilateral termination and release. So when a contract is terminated, it is terminated unilaterally, meaning one signature. It doesn't matter if a buyer's terminating or if the seller's terminating. What's at odds is the disposition of the earnest money. So once it's terminated, it's terminated. The question is, was the termination by an unexpired, agreed upon contractual contingency, or was the termination by default? In other words, once a buyer and seller go under contract, the majority of the contingencies in your purchase and sale agreements are buyer contingencies. They protect the buyer's earnest money if the buyer terminates by not being able to meet that contingency. If the buyer terminates prior to that time frame, then the buyer's earnest money is protected. There are very, very, very few seller termination rights in a purchase and sale agreement. But there are times when a seller terminates. The issue is the seller has typically terminated by default. So in the termination and release agreement, you must state the reason. And you guys, it's so weird how GAR does it. Termination and release are 2 separate contractual issues. They're 2 completely separate things. Once a contract's terminated, it's terminated. That's unilateral, and that's one issue. Like I said, the disbursement of the earnest money is a completely separate issue. And that happens by either agreement between the buyer and the seller telling the holder what to do with the earnest money, or if you don't have agreement, the holder can interpret the contract and send the 10-day letter, or the holder can interplead it into a court. That's a completely separate issue, but on GAR, they put both of these issues on one form, which makes it a bit confusing. And a lot of times a seller will terminate, and I'll get a buyer's agent contacting me saying, they can't do that. They can't do that. It's not the buyer doesn't agree. Well, guess what? The buyer doesn't have to agree to a termination. It's unilateral. What they don't agree to might be what happens with the earnest money. So the agreement to disperse the earnest money does require both the buyer and the seller signatures. Additionally, if you do a TNR, and that's what we call the termination and release, earnest money must be addressed. If earnest money is addressed in the creation of a contract, it must be addressed in the termination of a contract, even if it has not yet been sent by the buyer. In other words, let's say in the purchase and sale agreement, it says buyer to remit earnest money 4 days from binding agreement date. For whatever reason, the buyer chooses to terminate the purchase and sale agreement on day 2 after binding agreement date. In the release portion, you can't leave it blank. Earnest money is still part of the contract, even if it hasn't been remitted. So all you're going to put in the release section is earnest money not yet remitted per the contract to be retained by the buyer. So again, if it's addressed in the creation of a contract, you still must address it in the termination, even if it hasn't been remitted. Now, there's another form that a buyer and the seller can use to terminate a purchase and sale agreement, and that is the mutual termination and release, and that's GAR form F519. In this situation, you do need both buyer and seller signatures to terminate the contract. But also, in essence, this form is used as an out-of-court settlement agreement if somebody is needs to terminate, but basically they're in default of the contract. You could use this if they are still contingencies intact and you want to terminate it. But a lot of times this form is used if the contingencies have expired, but one of the parties needs to terminate for whatever reason. Then this would be the form that you would want to use rather than the unilateral. You would want to use the mutual termination and release because the buyer and the seller agree what happens to the earnest money. It can go back in whole to the buyer. It can go in whole to the seller. It can be divided up. But rather than the defaulting party risking one of the brokers pursuing them for commission, you can negotiate here that the amount to be paid by seller to the selling broker. So the seller can pay some to the selling broker, the seller can pay some to the listing broker, and so forth and so on. So again, this would be a better form to use if the parties have to terminate and all contingencies have expired, if you can negotiate through all these fees. All right, moving along to special stipulations. We got 25 minutes. So you want to limit your special stipulations as much as possible. Please, please, please try to limit them. You guys a lot of times get too special stipulation happy. And in essence, what you do is you end up what you think you are doing to protect your client, you are not protecting your client. So number one, do not write a special stipulation that addresses an issue that's already covered. If it's something that's already in the purchase and sale or an agreement, don't write a special stip because the terms of your special stip will supersede what's already been written by attorneys when they created these forms. For example, I saw a contract the other day. It was a GAR purchase and sale agreement subject to a conventional loan. The buyer's getting a conventional loan. And in the conventional loan exhibit, it completely goes over the appraisal contingency and what happens if the appraisal comes in low, what notices have to be sent, what forms have to be sent, what time frames this has to be done by, any termination rights of either party, what happens with the earnest money. All of that, you guys, is already addressed in the GAR loan exhibits and in the RE forms in the standard terms. So this contract came across and it had a special stipulation that said property must appraise for sale price, period. Well, guess what? That stip supersedes, special stipulations supersede exhibits, and exhibits supersede purchase and sale. So that special stip, you guys just undid everything that all the attorneys had pre-printed in that contract. Well, what happens if it doesn't appraise? I don't know. What kinds of notices have to be sent? I don't know. Does the seller have the right to agree to sell it for lower? I don't know. Can the buyer terminate and get their earnest money back? I don't know, because guess what? You didn't write all that stuff in your special stipulation because you are not an attorney. All you wrote is property must appraise for sale price when it was already addressed in the exhibit. You guys, please do not overwrite stuff that's already there. You absolutely do not protect your clients when you think you are protecting your clients. There are two libraries of special stipulations. one in the GAR contract form and one in the RE contract form. They are included in the handouts where I showed you how to download the handouts. You also always want to check with your broker or an attorney to get special stipulations. Now, let's go back to that issue of repairs. What if buyer and the seller have agreed upon an amendment to address concerns with the property, sellers agreed to do repairs, and you get right before closing, you do your walkthrough, and seller has not done the repairs? Can a buyer terminate? Let me rephrase that. Can a buyer terminate and get their earnest money back? Not necessarily. There are not automatic termination rights with protection of their earnest money in the contract if the seller fails to complete negotiated repairs on the amendment to address concerns. So don't leave that up to chance. That would have to be determined by a judge or an arbitrator. There are two completely valid legal arguments for both sides of that argument. And there was a court case heard in Georgia, and this was addressed in the Georgia Association of Realtors magazine that came out either last year or 2 years ago, where a buyer and seller had negotiated for repairs. Seller did not complete all the repairs. Buyer terminated, and it went to court, and the buyer was found to have been in default of the contract, even though the seller did not complete all the repairs. And in that specific case, the judge had ruled that the seller had completed some of the repairs, not all of them. In that case, the judge had ruled that the repairs that the seller did not complete did not constitute a material breach of the contract. So you guys, guess what? Don't let it go to court. There is lots of money involved and lots of hurt feelings and lots of issues. Nothing's an issue till it's an issue. Well, how do you prevent it from being an issue? You address this potentiality up front when you are negotiating for repairs. Regarding the two legal sides of that argument, I have done a complete lengthy video on this, and it's called Seller Doesn't Do Repairs, May a Buyer Terminate? Again, it is on that channel that is geared towards every agent in the state of Georgia with respect to contracts and license law. So here are some special stipulations that you are going to want to consider when you are negotiating for repairs. All parties agree repair work contemplated and agreed upon herein shall be completed not less than 3 days prior to the closing, dated of whatever. All work shall be completed by vendors licensed in the state of Georgia through proper state licensing board to complete the work required herein. Seller shall provide to buyer at least 3 days prior to closing evidence of their license to do the work, invoices, and paid receipts. Should the seller not complete the work required herein, at least in that time frame, buyers shall have the right to either immediately hire vendors of buyer's choice and have work completed at seller's expense to be paid at time of closing from seller's proceeds, or terminate the contract with full refund of all earnest money. See, you address what happens if the seller doesn't perform when you are going under contract for repairs. Additionally, here is a special stipulation from the RE forms to escrow a certain amount of money with an escrow agent if those repairs are not completed, and that take care of that after closing. Additionally, okay, what about these sellers? The seller's thinking, well, gosh, I'm not going to put money on repair. I'm not going to spend money on repairs. I want to limit my costs. So here's a special stipulation that would limit the cost of the repairs paid that they would perform. So there's another special stipulation regarding the seller doesn't have to perform any of the repairs until they get proof of loan commitment from the buyer's lender. So there's all kinds of issues when you guys are negotiating for actual repairs to be done. Again, I highly, highly, highly encourage buyers and sellers, if there are repairs that need to be done, as long as they're not required to be done prior to closing, I highly encourage that you handle it in one of those 3 ways I mentioned. Either additional contribution to closing costs by the seller, a reduction in the sale price, or a seller to pay a vendor of buyer's choice at closing. So just keep that in mind when you are negotiating for repairs. Okay, down payment assistance funds. You agents, that are working with your buyers getting down payment assistance funds like Georgia Dream funds. If you do not make the contract specifically subject to the buyer getting those down payment assistance funds, and the buyer does not get their Georgia Dream money, and they terminate on the contract, they will also default on the contract, because a buyer not having their down payment money is not a protection for them if they terminate under a financing contingency. Down payment money is not part of a financing contingency, and they're not protected. You must use this special stipulation. This agreement is contingent upon the buyer's approval for the receipt of down payment from blank program. That would be, for example, Georgia Dream, within X number of days from binding agreement date. Should the buyer not be approved for the down payment assistance program within the time frame, buyer may terminate without penalty, meaning they're not going to lose their earnest money, if the buyer notifies the seller in writing and provides the down payment assistance denial letter. Again, you have to use that to protect your buyer's earnest money if there's a situation where they might not get their DPA funds. All right, here's other special stipulations about termite letters. Again, this is a GAR special stipulation. Here is a special stipulation about a home warranty. Again, you guys sometimes will put in seller to provide buyer with home warranty, and that's all you put. Use this one from GAR instead. At time of closing, seller shall provide buyer a home warranty issued by whatever company at a cost to the seller not to exceed X amount of dollars. The term of this home warranty shall be at least 1 year from the date of closing. And then I suggest you guys would also want to put in home warranty to be ordered by, and you would put in either listing agent or buyer's agent. Sometimes a seller will already have a home warranty in place, so that's where you would want to address that. Okay, if a buyer chooses an amount for repairs and seller agree, how will the buyer get the amount at closing? To whom? So basically, again, you want to make sure the closing attorney gets that amendment. So the buyer is going to have to identify a contractor prior to closing and let the closing attorney know to whom the closing attorney is going to write the check to. So you go to closing, you close. At closing, the closing attorney is going to hand you a check for your portion, your broker's portion of the commission. Hand the other agent a check for the agent's, for that broker's portion of the commission. Hand the seller a check for their proceeds from selling the house. Then the closing attorney will hand the buyer a check made out to ABC contractor for the amount that was negotiated in that amendment. So that's how the buyer gets it. They don't get cash, they get a check payable to a vendor. It doesn't come back. Buyer does not ever get cash back at closing. They would either get a credit on the closing statement or they get a check payable to a vendor, but there's never cash changing hands between a buyer and a seller. All right. Also, you want to put this provision shall survive closing, and I'll talk about that in a second. All right. If you, buyer and seller, go binding with a counter offer form and one of the parties asks for a clean copy, you'll want to include this special stipulation on the clean copy that just says, if there was a typographical error, for example, and a conflict between the conformed copy and the original copy, the provisions of the original shall control. I'm just, again, pointing out to you guys some special stipulations that you're going to want to use. Now, survival. In the GAR purchase and sale agreement, it specifically states there are only 5 things that survive closing. Commission survives closing mean the parties are obligated, if they did not take care of that issue before it closed, they are still legally obligated to take care of that issue even after the closing. One is the commission. Parties are obligated to pay commission if it doesn't get paid at closing for whatever reason. The warranties of the seller survive closing. That means whatever the seller warrants about the property, that survives closing. If the property has been condemned, that survives closing. There's one I'm missing, but I can't think of what it is. Oh, title. The issue of title survives closing. And then the last one is Whatever the buyer and the seller agree survive closing shall survive closing. So for example, in this, oops, let me go backwards. Home warranty. If you just write that the seller is to provide the buyer a home warranty and they're supposed to pay for it. Let's say you as buyer, listing agent, and selling agent, you forget to call it in. You go to closing, property closes, the warranty was never ordered. Then the buyer calls you, their agent, up and say, hey, guess what? I never got a copy of that home warranty. I need that information. And the agent goes, oh my gosh, I forgot. So selling agent calls the listing agent and says, hey, guess what? Thank you so much. It was great working with you. Remember that home warranty we negotiated for? We forgot to call it in. So will you please go ahead and call it in and have the seller pay for it and then send me the policy number? And the listing agent says, so sad, too bad. Guess what? That home warranty provision at time of closing, seller shall provide with the home warranty, that does not survive closing. Buyer, you have to pay it for the buyer, or the buyer has to buy it themselves. Thank you so much. Have a nice day. And you said, no, 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 no. So sad, too bad, because I took Dana Sparks' class. And remember, I added that term, this provision shall survive closing. So therefore, the seller is obligated to pay for that. So please send me the policy number after the seller or you call in the home warranty and pay for that for the buyer. And the listing agent says, wow, when is Dana's next class? The reason, I hope you guys are laughing. The reason I say that is because the GAR survival clause in the purchase and sale agreement says that that anything will survive closing if the buyer and the seller agree that it survives closing. That's why something with a home warranty, with repair issues, if you actually do negotiate for repairs, you want to include this sentence. This provision shall survive closing, and then it would survive. Also, if buyer and seller go binding under the RE Forms Purchase and Sale Agreement, the survival clause in that contract says the entire contract survives closing. So this is just a phrase you are going to need in the GAR. All right, we're almost done, you guys. Hang in there. Commission instructions. Instructions to closing attorney. This includes the commission, again, as we addressed at the very beginning of class when the listing agreement. It includes the commission that is paid from the seller to the listing broker and then from the listing broker to the selling broker. On the instructions to closing attorney, it also has a place where, let's see if I have a copy of it. No, it also has a place where you guys can fill in any commission rebates or forms, fees that the public, that you are paying to the public. So let me show you guys. Now, I just want to show you guys where that is, because a lot of times agents are giving back rebates to buyers or sellers or buying a home warranty from their commission. And I want to show you guys where to put that on the instructions to closing attorney. So here is where, these are the instructions to closing attorney. This is where the total real estate commission paid for by the seller. And this is the listing is paying the listing broker. And then this is where the listing broker is sharing it with the buyer's broker. So this percentage or number up here in A must be larger than this number or percentage here in B. And then if the buyer has agreed to pay any overage or any addition, this is where that goes. But on page 2 of these instructions, let me make this a little bit bigger for everybody to see. This is where you guys complete instructions to closing attorney for any referral fees or commission rebates. So this is where the listing broker, if the listing broker is paying a fee or rebate, you would put, you would put, for example, listing broker to pay, usually you're going to do it with a buyer's broker, but it doesn't matter. Here's where you do it for the selling broker too. You're going to pay, well, here, let's just do home warranty here. Listing broker to pay $569 to seller. And over here, you're going to put, to ABC Home Warranty Company for home warranty. And under here, for example, you're going to put selling brokerage pay 1% of sale price to buyer as credit on buyer's closing, on buyer's side of closing statement. And over here, you're going to put commission rebate. So this is where you fill out all of that information so that the closing attorney knows how to put it on the closing statement. Again, you can't give money back to nobody can give cash back to anybody after closing. Buyer and seller can't exchange cash, and agents cannot give cash back to their clients after closing. It must be accounted for on the closing statement. Now, there is another form, and you guys, there are sometimes some issues with commission for a selling agent, especially with new construction, or there can be all kinds of discrepancies. I want to bring to your attention, there is another form. It is GAR F258, and it is called Co-op Commission Agreement, to be used prior to showing. You would absolutely want to use this to avoid any misunderstanding about commission before you show the property or write the offer. That could be with a co-op agent. That could be new construction that's not yet listed in FMLS or Georgia MLS or any MLS system. So you identify the property. You put commissions to be paid by seller. Same thing. You put the selling broker agrees to share the commission listing broker agrees to share the commission paid by seller with the selling broker. So again, you have no idea what the listing broker is getting from the seller. This is just an agreement, what the listing broker is going to share with the selling broker. And this is anything paid by the buyer. There's nothing here about rebates or anything else. These are not instructions to closing attorney. This is just an agreement between the listing broker and the buying broker so that the buyer's broker can be assured in writing of how much their broker is going to get paid before showing a property. Avoid any misunderstandings up front. All right, back to the slideshow. All right, just a couple of other forms to bring to your attention. There is a withdrawal of offer form, and these are the GAR and RE form numbers. Remember the definition of a binding agreement date. A contract is binding when all parties, when there is acceptance and notice of acceptance. So it's especially important. Let's say buyer's written an offer to a seller. Seller makes a counter offer back to a buyer. So the seller has an open counter offer back to the buyer. The buyer signs it. It is not yet binding if the buyer, until the buyer sends notice of acceptance back to the seller. So let's say the seller has a counter offer back to out to a buyer. Then they get a better offer from buyer B. Well, in that situation, you listing agents, you want to withdraw your counter offer to buyer number 1 and then accept offer number 2. If you don't withdraw your offer and you sign offer number 2, and then buyer number 1 signs your counter offer, the seller has just legally sold the property to 2 buyers, and I'm not sure how they're going to do that. I don't think they're going to split the house. It's going to end up costing the seller money to get out of one of those contracts. So please, this is especially important for sellers to withdraw your offer or counter offer. You listing agents, use this form, rejection of offer. If you are a listing agent and you get multiple offers and the seller accepts one offer, please, please, please send back this rejection of offer to all the other parties that wrote an offer on your property. This is going to protect you and your license from a GREC investigation. You have to be able to prove that you presented the offer or counter offer. Well, this is going to have your seller's signature on it, proving that it is the seller who rejected it, not that the seller never saw it. This can be used for buyers too for counter offers, but it's especially important for sellers, especially in a multiple offer situation. Bill of sale. This is a document when there are personal property items in a house that the seller is going to leave with the house. It's a receipt signed between the buyer and the seller. You guys will notice it's not an exhibit to the contract. You probably don't want to make it part of the contract because a lender doesn't want to see that there is personal property, especially if it's expensive personal property, that could be interpreted as an incentive for that buyer to buy the property. So again, it's just a receipt between the buyer and the seller, and this could be for $0. That is, and you'll see it doesn't even say exhibit. Few other forms. We're almost done. Hang in there. Reminder of important dates. This is after you go under contract. It's a form to keep track of binding agreement dates, all your contingency dates, so forth and so on. Great form to share with your client, and very, very professionally nice of you to share with your co-op agent to make sure everybody's on the same page. There's an estimated net to seller form, an estimated cost to buyer form. There is a vendor list where you as an agent can put in more than one name of home inspectors, home warranties, so forth and so on, with contact information so that your buyer or your seller may choose. There is another form called a broker information disclosure form that answers, it has a place, fill in the blank for a question, fill in the blank for the answer, and you cite the source of your answer, and there's absolutely a hold harmless. So for example, if a buyer says, has there ever been a leak in the basement? Well, listing agent would write out, has there ever been a leak in the basement? They get the answer from the seller, they write out the answer from the seller, and they mark the source is the seller. And again, there's hold harmless language. Again, there are a ton of consumer brochures in the GAR and the RE forms contracts. Protect yourself when selling a home, buying a home, new construction, condo, HOA, short sales and distressed properties, flood hazard insurance, lead-based paint, mold, radon, landlords, ABCs of agency. You guys use all kinds of EPA forms. You guys use those consumer brochures, use as many as are appropriate so that you can demonstrate that you've got information into the hands of your clients, everything as much possible, so that your buyers and your sellers can make an informed, consented decision when going under contract to convey real property in Georgia. Whew, we made it, you guys. Thank y'all so much. Please, again, confirm all contract questions with your broker. I showed you guys where you can find those additional classes. CE credits will be recorded in 3 to 5 days. Again, I have a YouTube channel. Obviously, I have to disclose that I am a maximum one broker per GREC license law. But please, I welcome you to please check out that channel and the playlist. I've got 4 or 5 years of contract tips where I go into depth in every one of these situations. And again, the handouts are available. And I'm going to stop my share. And that's it. Thank you guys so much. We're done. We made it. I hope everybody got some good information out of that class. I know that was a ton of information, but I really appreciate everybody's attendance. And I will be more than happy to stay and answer any questions, either through the microphone or through the chat.
I have a question.
Okay.
How do we record the credits? Do I have to send the license number to you or?
In the chat. So did you send your email address, your name, your email address, and your license number in the chat?
Okay, no problem.
Have you done that, Monique?
No.
Okay, go ahead and do that now.
It's not.
Hi, Donna.
Hang on.
Oh.
Because we combined the chat report. There we go. I just sent it again. We combined the chat report as well as the registration report and the attendance report.
Donna, are you hearing me?
Monique, I need all, but before you hit the enter key, enter all that information in and then hit the enter key. I know you're trying to get it on a separate line, but your name, email, and license number, and then hit enter.
Can we see your last slide, please?
My last one. Okay.
Slide, the register for real estate classes.
Yep, I will show you that, and I can still hear whomever wanted to answer another question, ask another question. There was another question.
Marriott.
Donna.
Yes, Donna, are you hearing me?
Yes, I can hear you.
Yeah, I was just trying to see whether or not you could give us that information again for the e-agent and the web so that we could go and get the copies of this? Can you repeat the information again, please?
Yeah, it's up on the screen right now. See the
Oh, that is it there. Okay then. All right.
Yeah, handouts available. Go to eagentweb.com. You're going to click on training videos and then just scroll through the page for the class, and then you'll see there are hyperlinks for PDFs.
Yes, I see.
It's a lot of paper, you guys. But they're there for you to keep as a PDF in your computer or to print out or whatever you choose to do. Any other questions, anybody?
Yeah, Dana, I have a question.
Okay.
So let's say you're a listing agent and you are receiving multiple offers, and you tell a buyer's agent that you have received multiple offers, and you said the highest and best that you've received so far is $375,000. Would you ever be in a position as the listing agent to prove to a buyer's agent, if the buyer's agent requested, well, you have received such an offer, could you show me that in writing, or do I accept that orally based on your word?
So that is a good question. And actually, you know what? I've forgotten to show you guys. Let me share my screen one more time. And I know some people may have left, so I apologize. But if on those handouts that I have for you guys, I also have, you guys get bonus. I have a ton of repair special stipulations that we discussed. I also have this handout 20. I know my screen's really, I can't zoom in. Handout 20. I have a ton of special stipulations to consider, and I apologize. I talked about the escalation clause and never went over it. Under this handout, special stipulations to consider, here's the escalation clause that I mentioned earlier. Buyer to pay X amount of dollars above highest received verifiable offer, not to exceed total sale price. So in the negotiations, no, you can't share, and even in this, you can't share a copy of a contract, because that is a contract and there's probably going to be identifying information. But you could, for example, perhaps copy and paste. You could share it as long as you perhaps mark out any identifiable information regarding the buyer or the agent. But if you're negotiating, so for example, in your, do y'all see, there's a ton, I've got pages and pages of special stipulations for you guys here. So again, this is bonus for you guys. Lots and lots and lots of stuff. So in answer to your question, number one, Rick, you absolutely would need to get your seller's written permission to do that.
Mm-hmm.
Number two, you have to be careful, because you can't do anything that would lead to the identity of anybody else.
Right.
You could potentially run into some potential fair housing issues. So, you know, you could verify it with the contract that for example, in that you would want to be able to verify it in an escalation clause, because you're obligating the buyer to pay X amount of dollars over the next highest offer. Well, you can't just arbitrarily say, yeah, that highest offer was $350,000, and now they're obligated to pay $351,000 when really the only offer you had was $275,000. So you would definitely want to be able to verify it in that situation because of the cost incurred to that buyer that went under contract. In the negotiation, no, I don't think you're obligated to verify. Hopefully everybody's doing the professional and right thing. Mm-hmm. And, you know, there's appraisal issues to consider as well. But no, not in the negotiation process, but in an escalation clause, yes, you would probably want to rethink that a little bit, because it has financial ramifications specifically for a buyer going under contract.
And that's why you suggested redacting or blocking out the buyer's name, the agent's.
Oh, yeah, you have to.
and all of that, but it
Absolutely.
does prove that you do have a contract, information, and I guess that protects you, especially in the escalation clause case.
Yeah, and I would, you wouldn't even have to provide the whole contract. You could perhaps provide, the first page.
A portion of it, correct.
Shows, yeah, and
Okay.
and maybe cut and paste. And again, that I would confirm that with, I'm speaking generally now, with your broker or with an attorney to verify that. But yeah, it's more important in an escalation clause situation, but not in just a negotiation.
With you. Thank you.
You're welcome. All right, I saw a question. There was a question in the chat. CE credits will be recorded in 3 to 5 business days. If you, Lachelle, if you're still on, I'm gonna ask you to contact Heidi. She is the coordinator of the school and she records the credits. So I'm gonna send you her information in the chat. Or you can always email me, but Heidi does them, so eagentweb.com. All right, Lachelle, I just sent that to you in the chat. Okay, there was another question I thought.
Dana, I'm just curious about something that you had mentioned about the stipulations.
Okay.
Regarding, anything, I guess, that you put that's surviving the closing. So if you don't put surviving the closing and it is in stipulation, because I was thinking that just, as long as it's in stipulation, it's covered because they both, the contract.
It doesn't survive the closing.
But they both signed the contract.
Right, and the contract ends when?
Well, when it closes, but it was in there.
Closed.
I guess I thought because it was in there prior to closing. So.
No, the contract, the obligations end at closing unless they specifically survive closing. So what survives closing is specifically delineated in the purchase and sale agreement itself. In the GAR purchase and sale agreement, what survives closing are those specific items. In the RE forms purchase and sale agreement, the whole contract survives closing. What you're thinking is a provision of the RE forms purchase and sale agreement, but not of the GAR. In a HUD contract, a new construction contract, I have no idea what survives closing.
You know what? I was using the RE for a while, so that's probably, yeah.
Yeah,
okay.
Yeah, good question. All right, Jennifer has a question about special stipulations under the amendment to address concerns, termination prior to. So a couple of issues. If you want to put that in the special stipulation in the purchase and sale agreement, you may not want to do that, because if the issues that you would address in the amendment to address concerns are just little things, like I said, replacing rotten wood, repainting, reversing GFCI, a buyer, if the seller doesn't agree to do that, a buyer may not want to terminate. Well, if you've included that in a special stipulation of the purchase and sale agreement, if the seller doesn't agree to those little things, you've just terminated the contract on behalf of your buyer by virtue of that being a special stipulation in the purchase and sale agreement. So that's why I would say it depends until the buyer has that property inspected to see if there is in fact a make it or break it issue, if you want that to serve as unilateral termination. And you would just have to either add an additional page to the amendment to address concerns or type it in there. Now, you don't have to use that. What you could do is, if it is a make it or break it issue, don't add that issue in that amendment to address concerns. Go ahead and prepare a termination notice, and then make sure you send that termination notice, have the buyer sign it, and send it prior to the end of your expiration, end of your due diligence. But I wouldn't necessarily include that unilateral termination in the special stips, because the buyer might not want to terminate. So I hope that answered your question. Does a special stip stick, easy for me to say, if put into an unsigned, it depends. Not on the amendment to address concerns, you guys, none of it matters if the buyer and the seller don't sign it, just like any amendment. It's not, it does, none of it sticks if they don't agree. Thank you, Rick.
Hi, can you hear me?
I can hear you.
Okay. I had a question regarding the rejection form. No one really uses that. Is there anything that we can hold to them or demand that we get a rejection form?
So that, especially in this multiple offer situation, the question inevitably comes up. Did you even present my offer? Did you even present my offer? My buyer made the best offer. I can't believe you got an offer better than mine. I don't think the seller ever saw that offer. And license law says we must present all offers, right? So I'm saying that as a listing agent, you guys protect your license, prevent a potential GREC investigation by being able to demonstrate and prove that, yes, in fact, it was the seller that rejected it. So do you want to use that form? I would say so. If not, the other thing I would suggest is the offer that came from every other buyer other than the one the seller actually accepts. Take a pen and draw I'm looking for a piece of paper. Of course, I don't have one handy. Draw a big old huge, this is the front of the purchase and sale. It disappears in my green screen. Draw a big old diagonal line across the first page of the purchase and sale agreement. Write rejected, have the seller sign and date it, and send that back to the selling agents. Again, I'm just saying this to protect you and your license and to keep you in compliance with license law. So on the other side, if you're the buyer's agent, I don't think you even, presented it. Send me back a rejection notice. Hopefully the seller will, the listing agent will. Hopefully you'll get either the contract with that rejection notice or that form. You could get the listing agent's broker involved, or you could petition GREC to request an investigation, which will be heard a year to 18 months from now. But I think it's a good practice for listing agents. Any other questions?
Yeah, Dana, just on the special stipulations that you just presented, was that in the same location as the other information?
Yes, sir, it is.
All right,
and there's a whole page of repair special stipulations too. All those ones that I mentioned briefly in my talking nonstop for over 3 hours, where I talked about, the seller is not obligated to perform repairs until they get proof of buyer's loan. I can't think of the word right now. That the buyer's going to get their loan. All of those things are written out in there. And I also printed for you guys to download a copy of all of the GAR special stipulations and all of the RE form special stipulations. I'm giving you guys a lot. Happy birthday.
Thank you. Thank you.
And again, these Zoom classes are absolutely great on saving me money in paper costs and copying costs. Those of you who have been in my in-class classrooms, you guys know I hand you guys all this stuff. But this way you can keep it on your computer to use as a reference. Because again, I like giving handouts with stuff already underlined, especially because you guys aren't in class and can't underline the contracts yourself. And again, I invite you guys to please scroll through all of those classes. I have handouts from all of the classes that I have taught. Again, the GAR Contracts class, the RE Forms Contract class. You are more than welcome to download whatever copies of instructional and informational handouts you want. My philosophy, our philosophy here at the Georgia Real Estate Academy, as well as my personal philosophy with the Real Estate Made Crystal Clear YouTube channel, as well as the philosophy of Maximum One Companies, is we cannot stress education and information and training enough. The better trained and educated every real estate agent is, the better it is for our profession, the better it is for our public, the better it is for all of our brokers, and the better it is for you guys as agents, regardless of which broker holds your license. So I am all about sharing because it makes us better. And we teach a ton of classes. There are agents affiliated with small brokerages that don't have the opportunity to take classes. There are agents with large brokerages that aren't necessarily affiliated with a school that have, we've had our school for a long time and we've got a ton of classes, and I just love teaching. It's one of my favorite things to do. So please, we give and share anything informational and educational that we can. And you guys, that's why we try to make the majority of our classes at no cost. We welcome agents from any brokerage throughout the entire state of Georgia. As I mentioned, we get some agents from other states, which I hope the information helps, but I can't give you CE credit.
Gotcha.
And I just welcome, I like seeing everybody. So I thank you guys so much for your time and attention. Again, please go ahead and start registering for the September classes. We're working on the rest of the year as we speak. They will all be virtual. Not sure what we're going to do after the first of the year. And there are lots of buyers and sellers out there that need your help. So please continue to be a blessing to the public as well as to each other by your real estate license, your knowledge, your experience, your skill, your excitement. And we look forward to seeing you guys in the next class.
Dana, this is Brooks Coleman, your real estate auctioneer. Thanks. Another good job. Thanks for letting me be part of it.
Thank you, Mr. Coleman. My pleasure. Thank you, everybody. Have a great day. I appreciate it.
All right. Bye-bye.
Bye, everybody.
Thank you.
Bye-bye.